Yes, we can hear you in the door.
No, that's easy. I just saw Kathy.
Okay.
Yeah. What's going on with our screen here? Are you still with us in New York there?
We can hear you. Can you see us?
We can see you and hear you.
Yeah.
I see Marvin and I see Barry.
What else is there, Mike?
I'll let you answer that, Barry. Well, I want to take a minute and welcome everyone, thank everyone for not only being at the meeting, but for all the work that people have done between our meetings. The first item on our agenda, and then hopefully everyone got the new agenda that we sent out, but the first item is a review and approval of the meeting agenda. Any comment? If there's no comment, do we have a motion to approve the agenda?
So moved.
Second. All in favor?
Aye.
Anyone opposed? Next item we have is review and approval of the minutes for our December 19th meeting. Any comment with regard to the minutes of the December 19th meeting? No comment. Do we have a motion to approve the minutes?
So moved.
All right, do we have a second?
I second.
All right, all in favor? Anyone opposed? The next item we have is matters for executive session. I would ask if we have a motion to go into executive session to discuss matters that relate to a pending investigation and could impede law enforcement if disclosed, as well as matters that could lead to discipline or dismissal of personnel. So do we have a motion to go into executive session for those reasons? All right, second?
Second.
All right, all in favor?
Aye.
Anyone opposed? All right, then we will be in executive session for a period of time. I would ask everyone who's not with the commission to. Thank you. Looks like we lost Marvin and Barry. I see Barry there.
So extend it a little bit?
No.
For personal?
No.
Is that Marvin on the left?
Just one, babe.
Barry, are you ready? Marvin?
I'm here, ready to go.
All right.
Barry?
You can note that we're back in regular session now, and again, my apologies to everyone other than the commission members, but thank you for your patience. I should note that there was no formal action taken during the executive session. Our next item deals with lab accreditation and updates, and I'm going to ask Brian if he could take us through those.
The first issue we have on there is the Yonkers Police Crime Laboratory. There's a letter in the binders and on the public site from ASPAD Lab dated December 31st, granted international accreditation for a period of 5 years from the period of December 18th, 2012 through December 17th, 2017. And there's also a scope of accreditation and a final assessment report. So at this point, there is a need for a vote for New York State accreditation. So the Yonkers Police Laboratory is up. If anyone has any questions for the laboratory, Chris Cheney's here. Are there any questions for Yonkers? Okay, if not, what we need is we would need a vote to have a 5-year accreditation for the Yonkers Police Crime Laboratory for New York State accreditation, and I would like to make that motion.
Do we have a second? All right, all in favor? Barry or Marvin, are you voting yes on this one?
No, I'm not voting yes. I'm abstaining.
Okay. Anyone opposed? And Barry, are you abstaining as well?
Yes.
We have the vote recorded?
Okay. Thank you, Chris.
Okay, I do have one quick thing. Since the commission has asked for 3 days' notice when the lab director is changing, I have my retirement papers here that I will get to the commissioner. I am moving to Texas, where I'm going back to the bench to do trace work. So, there's one for you. One for
Congratulations and thank you.
Thank you for the.
It was nice working with all you guys. Same here.
Okay. The next on the agenda is the Onondaga County Center for Forensic Sciences. There's a binding recommendation from the New York State DNA Subcommittee dated March 15th, which is carrying on their New York State accreditation in the discipline of biology. There's also a letter from ASCAD Lab dated February 19th, 2013, granting reaccreditation for a period of 5 years. That's a period from April 4th, 2013 through April 3rd, 2018. There's the final assessment report that's also included in this package. So similarly, the Onondaga Center for Forensic Science will need a 5-year vote for continuation of their New York State accreditation. And again, I would like to make that motion to allow the Onondaga Center for Forensic Science to continue with the New York State accreditation for the next 5 years.
Second.
All right, prior to the vote, do we have any discussions, any questions? All right, then we have a motion, we have a second. All in favor? Anyone opposed? I'm sorry, Barry, was Ed in favor?
Abstentions.
Yeah, I
abstain.
voted in favor.
Okay, thank you.
I abstain.
I hope I
Okay.
don't live to regret that vote.
Thanks.
We have 2 abstentions.
What the hell's wrong with Myra? Myra, wake up, start voting on these things.
That was Fitzpatrick, Marvin, not me.
I heard Fitzpatrick.
Okay. Next on the agenda is we have the New York City Police Department Police Laboratory. There's a letter from ASCAD Lab dated March 7th, 2013, granted reaccreditation for a period of 5 years, a period from March 20th, 2013 through March 19th, 2018. There is also a final assessment report from ASCAD Lab dated March 6th, 2013, and included in the binders also are the ASCAD Lab International Scope of Accreditation, the Certificate of Accreditation, and the obligations of accredited laboratory. So we have Chief Pulaski and Dr. O'Neill from the NYPD. Are there any questions for the NYPD?
Where? Oh,
Okay. If there are no questions, I'd like to make a motion that the NYPD granted 5 years of New York State accreditation. Any second?
All in favor? Anyone opposed?
I'm sorry, Barry, is that an opposed or an abstention?
no, I voted in favor.
Okay.
I think there's just a little bit of delay here. All right, and then Marvin, you're abstaining?
I am.
Okay, thank you.
Okay.
Just a point of
I would-
clarification. These are 5-year certifications, but they're still required to do their annual self-assessment, and they're still required to have a 2-year inspection by ASCLD, correct?
No, annual.
Did you do that?
Annual surveillance.
Annual surveillance.
Annual surveillance under the ISO program in order to maintain their ISO accreditation. And if they lose their ISO accreditation, that would also cause their New York State to become in jeopardy.
Okay, but, so in effect, we've slipped from a 2-year accreditation to a 5-year accreditation by adopting the ISO program with ASCLD.
No, because essentially what happens is every single year there's someone from ASCLD coming to the laboratory and going through their
A surveillance assessment is not the equivalent to an accreditation assessment. They're not. They look at a subset of selected items. I'm not saying I'm in opposition to this change. I'm just trying to clarify in my mind it is a change.
The choice of the word slipped certainly had a connotation there,
Well,
but in any event.
yes, it is less rigorous than a biannual inspection. In my opinion.
I think just looking at the 2-year versus the 5-year in a vacuum without considering any of the other factors involved, you could certainly draw that conclusion.
I was just clarifying, it's now 5 years with annual surveillance. Okay.
Did we get the vote recorded for New York?
Yeah, I just like to state for the record in the minutes, that, it seems unfair, in my mind, not to vote for accreditation of those laboratories that have done what the commission has asked them to do. But I want to make it clear, and I don't know if abstaining is the right way, although I respect that vote. But I personally am wholly dissatisfied with the rigor and the procedures used by Askeladd Lab, and I know that the commission as a whole has been looking into alternative methods for lab evaluation. So while voting in favor of these accreditation judgments is really, by me, just so you understand it, is that, if you set out certain rules and people play by those rules and they don't violate them, I can acknowledge that. But I'm wholly dissatisfied. And the experience that we've had in the commission, both in public and in executive sessions with all these investigations, and with the whole issue that we've had with Askeladd Lab, I'm wholly dissatisfied with the way they do business. And these new regulations and these ISOs and everything else is not getting to the core of the problem. So I just want that on the record, because unfortunately what I find is that people will come in and they'll say, certain commissioners voted to approve certain things at the New York Forensic Science Commission, and all of a sudden you have people showing up in courts and testifying that I approved it, or Peter Neufeld approved it, or Marvin approved it, or whatever.
They won't say Marvin.
They won't say you, but they say that. Even when it is a so-called binding recommendation of the DNA subcommittee. So I just felt I had to put that on the record and what the qualifications are. We're all team players here, but, as a team, we should really look at Askeladd Lab and what it is or isn't doing for us. I have severe problems with them, just so you know.
Thank you. Appreciate the opinion. And on a lighter note, I guess I would say that's one of the burdens of being as famous and well-respected as you are, Barry.
I don't know.
I still think Peter Gallagher was a stretch.
No, but Michael Perlin testified in a capital case in Alabama that the true allele system should be accepted as scientifically sound because we voted for it.
No, I understand the point.
He endorsed it. That was wrong.
The next item on the agenda is the Nassau County Office of the Medical Examiner Forensic Toxicology Laboratory. This laboratory is in the process of changing, or actually has changed, from Askeladd Legacy to ABFT. Included in the packets is a letter from ABFT dated March 26, 2013, granting accreditation in the discipline of forensic toxicology from a period of March 1st, 2013 through June 30th, 2015. There's also an ABFT checklist for the inspection on December 17th through 18th of 2012, and there's also a certificate of laboratory accreditation of forensic toxicology for the period of March 1st, 2013 through June 30th, 2015. I'm not sure if we have access to Dr. Avila, who's the lab director.
Should be in New York City.
Dr. Avila, are you in New York City if there's anyone who has questions? Don't be shy.
Hit the red button as soon as he says it.
So are there any questions for the Nassau County Medical Examiner Forensic Toxicology Laboratory? Dr. Jenny?
Hello? You hear me okay?
Yes, I hear you.
Okay, wonderful. There were no citations of deficiency in the lab report, but there were 3 recommendations for improvement, and they could be interpreted to be significant improvements. Have you opted to incorporate those recommendations?
Yes, and if you'd read the laboratory, their report, there were not only recommendations, there were also suggestions. It was my opinion that we should adopt all of those recommendations and the suggestions made by the ABFT. So we have done that, and we have incorporated them.
All right, very good. Thank you.
Other questions for Nassau County Forensic Toxicology? In lieu of that, I'd like to make a motion that we have actually, their period of New York State accreditation, in my opinion, should mirror the accreditation from their provider, so it'll be through June 30th, 2015. So the motion I'd like to put on the table is for New York State accreditation up until June 30th, 2015. Anyone second? Okay, Dr. Stodger?
All in favor?
Aye.
Aye.
Any,
Hold on, there might have been a delay. Marvin, was that you voting yes?
This is ABFT.
ABFT,
Every 2 years. Every 2 years.
EFT certification.
Accreditation, you mean, right?
Yes.
anyone opposed? And anyone abstaining?
Barry, anything?
No, I think you voted yes.
Okay. So this is unanimous?
Delegated my vote to Marvin.
Okay.
Okay. Last, under that section is the Westchester County Department of Labs and Research, Division of Forensic Sciences. They had the ASPAD Lab surveillance visit report that was conducted on February 21st, 2013. There's no vote required. It's just an update. I'm not sure if anyone from Westchester is available. Does anyone have any questions for Westchester? Afternoon, Bob. Anyone have any questions for the director from Westchester? Okay. Thank you, Bob. The next
As you can see, the next set of items, I think there's 3 of them are extensions of New York State accreditation. Again, Brian, if you want to take us through those.
Essentially what this has is these laboratories are currently in the process of changing their accreditation or getting reaccredited. So what's happening is the granting of an extension will allow these laboratories to go through the time frame for these other providers. So the first one is the New York State Police Crime Laboratory. There's a letter to DCJS dated January 28, 2013, requesting a 6-month extension of the New York State accreditation. Currently, their accreditation expires on June 20th, 2013. So this would allow the New York State accreditation to go on for another 6 months, so that way that would not sunset on them.
Have you scheduled or in the process of scheduling a date for the inspection?
They have a date. They're coming in the week of May 6th.
So currently, ASPAD Lab is coming to the laboratory to do the assessment. This will allow the laboratory to be assessed and respond to any of the findings or issues that might come up during that assessment. So I'd like to make a motion to have the New York State Police Laboratory have their New York State accreditation extended for a period of 6 months. Their accreditation currently expires from New York State on June 20th, 2013. So this would be for another 6 months in that period.
So moved.
Okay. Second.
I had a question.
Dr. J?
It's a general observation or comment that there are many requests for extension. It begs the question, why isn't planning such that we don't risk, the accreditation schedule?
There's 3 that I see in front of us here: New York State Police Lab, Westchester, and Suffolk.
But there were several others, I think, that are postponed to another meeting.
Right.
I don't think, looking at the dates on those, I don't think there's a need at this point for an extension on any of those. There's 3 of them right now that are listed on the agenda that appear to be in situations where potentially, I think the state police has just indicated, May 6th for an inspection. We could not grant them an extension and take the chance that the process is complete before our, June 26th meeting. But if for some reason the process isn't complete by then, we leave them in a position where potentially they don't have New York State accreditation.
I understand the rationale.
I can't tell you what the delay was, but in our case, we filed the application back in October for them to come in.
I don't think we're raising the question about even the lab's planning, but our accrediting agency or entity is apparently has difficulty responding either in a timely way or in scheduling their board meetings and I think I would have raised the same question that Dick's raising and have said that I think we need to go on record that we're not going to do this anymore. When all the labs have moved to the 5-year schedule and they know when theirs is due, then they don't get an extension because they didn't file or ASCLD lab didn't come or the board's been slow or there are deficiencies to be looked at. Do your planning, get it done because, when the date comes, the date comes.
I would significantly argue against that for the main purpose of now, especially with the Federal Commission being stood up and the idea of what New York State started and was the first state to do, which was to mandate accreditation. If we look that other states that have not done that are now coming into the fold, obviously, even if we had multiple accreditation vendors, these vendors will be overwhelmed with applications. To penalize New York State laboratories would be criminal.
No, we're not penalizing the labs. We're just saying, since you know it's critical, get your application in 6 months earlier.
Potentially, you could be penalizing the labs if the process doesn't finish. And, you're certainly...
Now, technically, I believe, legally, their New York State accreditation does not actually end unless the agency takes active effort to end the accreditation. It stays in effect unless it's revoked. So you don't even really legally have to make these extensions. You just approve the next one, and as long as you didn't take it away, they still had it. But I just think it's really unfortunate that we've delegated our accrediting responsibility to an entity that has limited resources, yet they're willing to take all comers, all applicants, and then it hangs up the labs in being able to get the documentation that they need. So I'm going on record as saying I think this is a problem, and I don't think we should pro forma approve extensions unless there truly is an extenuating circumstance, and the unavailability of that paid accrediting agent should not be sufficient. That's my opinion.
As long as I support that, I think it's a misunderstanding of this National Commission and what it's going to do and what requirements it's going to make to believe that should be an excuse for Askeladd Lab not to do anything and not to have people available. That's all wrong. This National Commission is looking at scientific standards, and it's directed at federal laboratories, which is not to say that it isn't going to have guidance groups so that we can have more informed scientific standards with respect to many of the disciplines here. It may have effect, frankly, on whether it's worthwhile to do anything right now in terms of certification until the guidance groups get going and we have a better idea of what's really required scientifically. But certainly, what Commissioner Willie is saying with respect to the availability of Askeladd Lab, I have zero sympathy for any excuse that these people are not available, and that's the reason that some lab can't meet the requirements that have been set forth in the Commission. That's just not right. Then let's get a new vendor, which I think we should probably, or vendors, which I think we should be doing anyhow, as you all know. But I think she's 100% right about that. And that National Commission, Brian, should not be used as an excuse for Askeladd Lab with respect to anything. I think you misunderstand what its purpose is.
I don't believe I do with respect, but more important, it's not an excuse, but this commission is designed to support and have oversight of laboratories, and penalizing them for factors that are beyond their control as external bodies are coming out is neither in the benefit of this commission nor in the benefit of the furtherance of quality and forensic science. That's my opinion.
Nobody wants to penalize laboratories for things beyond their control. So if it turns out that laboratories can't get things done because Askeladd Lab doesn't have personnel available, then we have to do something about Askeladd Lab. It's not the fault of the labs. But that's not a good excuse, and it certainly has nothing to do with this National Commission. If what you're saying is the National Commission is requiring more laboratories to be accredited, and so they'll all try to get Askeladd Lab to do the accreditation, and they'll be overextended, that is bad reasoning.
All right, thank you, Barry. Now, any other comment before we go ahead, Marvin?
Yeah, I know that there's a report later on that we're going to consider about a quality assurance committee that was authored by Brian. I'm a little bit behind Barry. I don't understand, Brian, this posture of the National Commission. You're obviously seeing something.
All right, I'm going to stop this right now. No, Marvin, I'm stopping this. We have a specific issue in front of us related to whether or not we're going to grant an extension to the New York State Police Crime Lab. You can raise issues with regard to that particular matter when it comes up on the agenda later in the meeting. But right now, it's a very narrow issue. Yes or no, are we going to grant an extension to the New York State Police Crime Lab? If you have questions for the State Police Crime Lab, if you have comments for the Commission on that issue, by all means, go ahead. But the other issue will be handled when it's on the agenda.
So the question for the State Police Crime Lab, is the request for an extension here in any way due to the unavailability of ASCLD Lab personnel, examiners, or anything else in regard to that?
No. We anticipate the inspection to occur on May 6th, and part of our reason for requesting an extension is the report would be received from ASCLD on or about the time that our certificate is due to expire, and we anticipated some difficulty in getting both ASCLD Lab and this body to convene in order to grant us our accreditation. During the summer months,
Well, what's your problem with, forget us, what's your problem with ASCLD Lab? Why do you anticipate they won't be responsive? That's my question.
my understanding is it requires a board of directors meeting, which at the report would be to us about 30 days after the inspection. Depending on what day that report is actually issued, we weren't completely confident that both the board of directors and this body would be able to meet in time to grant us our accreditation.
Right, so logically, pursuant to Dr. Jenny's line of inquiry, did you request that ASCLD Lab in any way expedite this? Did you plan ahead of time for what you anticipated their delays to be? And is there anything more that you would want from them in order to make sure that your compliance is timely?
We have complied with ASCLD Lab's recommendation to apply for reaccreditation 6 months prior to our certificate expiring. We applied back in October. So we have complied with their recommendation as far as scheduling.
So in other words, you complied with their recommendation as to scheduling, but because of the way they operate, you cannot be confident that they will respond to you in a timely fashion, which I think is really the thrust of what Dr. Jenny is asking you.
Yeah, I think what I'm saying is that perhaps this commission should inform ASCLD of its expectations for the timeliness of inspection, anticipating a need for laboratories to respond with corrective action, and that ASCLD Lab to review and make a decision. So ASCLD Lab needs to be aware of New York State Commission's schedule of approvals and renewals and abide by that schedule.
Any other comment or question?
That's the least that they should do, given the amount of money we've been giving them over the last 2 decades.
Any other comment or question with regard to the extension for the New York State Police Lab? All right. I believe we had a motion made. Do we have a second?
No second.
All right. All in favor of granting extension for the New York State Police Lab? Anyone opposed?
One abstention.
One abstention. All right. Thank you.
What happened to Dr. Janney's motion to notify ASCLD Lab?
I don't believe anyone made a motion.
I make a motion that the commission inform ASCLD Lab and ABFT of the schedule of New York State Commission Forensic Science approval of laboratories, and that the accrediting organizations perform their duties in accordance with that schedule.
Seconded.
All in favor?
What,
Can I just have that read back? I'm not sure I understand it. Or say it back again.
Well, that we need to inform our delegated accrediting organizations, right now ASCLD Lab and ABFT, that when a laboratory, when they know that their accreditation is ending on a 5-year or 2-year cycle, that we would expect that accrediting organization to make all effort to provide the necessary inspection and response and board review so that that laboratory can expect to have in its hand at least 30 days prior to the expiration of their accreditation date the completed accreditation recommendation. Then we could always meet within 30 days. We do meet every quarter. I mean, we know we're meeting June 26th. I don't think it's going to help any to tell Askeladd Lab that this inspection they're doing May 6th needs to be completed and board reviewed by the 26th of June. You're absolutely right, it's unlikely that will happen by the 26th of June. And the next meeting isn't until the end of the summer, so the accreditation would have expired and they need the extension. But where was Askeladd Lab between October 1st and May 6th when you knew the lab's accreditation ended in June?
But didn't we say that this commission will grant accreditation for the same period of time? So if somebody gets a letter from the accrediting body, let's say June 25th, even if we don't meet.
But we'd have to, I mean, you can use that legal out that says if we don't take it away, they still have it. But we've always wanted to have met, reviewed it, and made a positive decision before the expiration date. But that means that Askeladd Lab needs to be able to provide to the lab the full documentation that they have been accredited prior to the expiration date.
Now, technically, it was your motion. Does that accurately sum up your motion, or do you want to remake it?
No, I wish to stand by the motion, just to clarify that it's not a burden to the laboratory. It's just a clarification to the accrediting organizations of the needs of this commission. Those approved accrediting organizations, serve this commission. And if we are held to a schedule of approval, then the accrediting organizations need to support that schedule.
But just as a comment, it'd be unfair to, penalize or take it out on the labs who act in good faith, if an accrediting body doesn't come through on time.
Well, I mean, and I don't think we have ever failed to consider a request for an extension. But when we get faced with 9 of them.
Now you have 3.
No, today there are 3, but there were 6 others in the book that have been removed.
Yeah, because there was no need for them to be on today. Let's just be accurate with the facts. If you want to criticize, but do it fairly based on the real facts, all right?
I think the idea here is to be protective of our labs and demanding on the vendor. And let's not forget that the IG's report, in excruciating detail, pointed out all the different problems that existed with Nassau and the extensions and the failure to actually tell all of us and make accurate recommendations about what the failures were there. So this is what we ought to get from a vendor to whom we're delegating some serious responsibilities. Let's be honest. All that we can do as a commission is look at the paperwork and ask appropriate questions that we get from those that we have delegated to do these inspections. And the labs are entitled to get timely responses. Otherwise, they can't make the adequate showings to this body. So I think Dr. Jenny's motion and Commissioner Willie's amendment to his motion are extremely important.
Did you get the clarification you wanted?
I guess my question is, are we recommending to Askeladd Lab to try to meet the dates? Is that?
As I understand the motion before us, it's to... Excuse me? As I understand the motion before us, it's to have the commission write a letter to both of our accrediting inspecting organizations, telling them of the expectations of the commission in terms of them having their process done, completed, and decisions to the labs prior to the meeting that precedes the expiration of that laboratory's state accreditation. Does that accurately sum up your request?
There's no sanction imposed if they don't meet that.
No, right now, as I understand the motion, it's a motion requesting that a letter that I assume would be drafted by Brian and sent on behalf of the commission to Askeladd Lab and ABFT outlining what I just said. Does that accurately sum up what the motion is?
So we're not I would just add as a friendly amendment to it, and that we indicate that the commission has an expectation that they will be able to accommodate our laboratories so they can meet their deadlines. And if there's some reason that they cannot abide by that scheduling, they should tell us so that we can try to solve this problem.
But I think we should also just keep in mind and or add that should they not meet those deadlines, the labs I'm talking about, that we're not going to grant extensions any less liberally and freely as we have been, because again, we don't want to be penalizing the labs or
We
the
don't
lab
want to
directors.
penalize them. We will consider legitimate requests. We have to be able
Right,
to do
okay.
that.
I mean, this is- because
that's
that's how
why
it's-
we're putting
that's
the
how
onus on the vendors.
I mean, that's how the motion started out, and I think
Well,
we've
that was my opinion being expressed. That was not the motion Dick made.
All right.
Yeah, and I summarized what was said. Frankly, my opinion is there's no need to write a letter, but, I was just trying to summarize it so we're all clear on what's on the table here and what we're voting on.
Okay.
Well, the only reason I'm making this amendment, the only reason I'm proposing the amendment, and let's just be clear about it, is as Commissioners Murphy and Fitzpatrick and our chair well knows, this is a lawyer's letter, right? We have a legal situation where we have now been informed by our laboratories on repeated occasions that they can't meet deadlines that they're setting because the accrediting bodies can't get back to them in a timely fashion. And it may be nothing more than not informing them of the schedule. But the point is, we have an expectation that they should be able to accommodate our laboratories, and if they can't, they should tell us why so this problem can be solved and we don't have to be granting endless extensions. And you've got to give them fair notice of the problem. That's all, Mike.
All right, any other comment?
I just have a comment that it's not just the accrediting body's schedule and information about that schedule. If a lab goes through an assessment and has corrective action, they have 180 days in which to complete that corrective action, and the accrediting body will not vote on them until everything is all complete. So just as anybody's aware that has to be considered as well, that Askeladd Lab could not, if, for example, in this case with state police, they could not, they had corrective actions from this assessment in May and couldn't complete them until, months and months later, that schedule can't be met.
But hypothetically, that represents a very different situation where now you have reason to believe there are perhaps significant deficiencies that a lab's going to take 180 days to respond to, and the commission might have to say, no, we're not giving you an extension. You're in the doghouse for the 180 days, and we'll consider your crediting you when you fix it all. Unusual, unexpected, but hypothetically it could happen.
But then you're almost asking the labs to apply a year ahead of time so that they could, have their assessment scheduled, and that is also difficult. I'm just wanting to point that out.
Not such a bad thing on a 5-year cycle.
But on a more realistic note, if the labs have to show compliance that they've actually fixed the problem, you're preventing them to show compliance because you're going to shut the lab down before they can show compliance.
No, we're
so it's
just
making
saying
a catch-22.
There's no motion on the table to shut any labs down. The motion is to send a letter asking them to comply with the schedule, basically.
Expressing expectations.
We've got a motion. Does anyone second the motion?
Yeah, I'll second.
Second.
All right. Anyone in favor?
Aye.
Anyone opposed? Looks like that carries. Did you get the votes or no? You want to, all right, everyone in favor, anyone in favor, again, raise your hand just so we can record the votes.
Yeah, it did carry.
So do we have 7?
Yes.
Anyone opposed? All right, so that does carry. All right, Brian, you draft a letter for us? All right.
Make it strong, too, Brian. Tell them what. Tell them we mean.
We'll have you proofread it for us.
The next item on the agenda is the Westchester County Department of Public Safety, and a letter dated March 8, 2013, requesting a 6-month extension of their New York State accreditation. Their current accreditation expires on April 23rd. There's a letter from Askeladd Lab.
Oh, did we vote on New York?
Did we?
Yeah, we did.
Yeah, we did.
I'm sorry.
It was all 4 except the superintendent abstained.
Okay.
I apologize.
So, sorry.
I
Sorry,
have
Madam.
it on documents.
I'm sorry?
Which Westchester one are we?
This is Westchester Public Safety.
Oh, we're skipping these. Okay.
So the documents, I apologize, are a little shifty right now, but essentially what we've done is their current accreditation expires on April 23rd, 13 days from today. So they have a letter from ASCLD Lab granting an extension through October 24th. Sergeant Dowd, the director of that laboratory, is currently in residence here. You have a inspection already scheduled?
Not yet. The document review is ongoing with ASCLD Lab with our staff inspector. Our application has been accepted by ASCLD Lab. We're hoping to have ASCLD Lab in I'm hoping for July, to give us enough time for any corrective actions. If this extension is approved, that will take us through the October expiration date.
Other questions for Sergeant Dowd from Westchester? Motion to grant an extension for 6 months for the Westchester County Department of Public Safety. Seconded. All in favor?
Aye.
Okay.
Anyone opposed?
Thank you, Sergeant Dowd.
Thank you.
Last one is the Suffolk County Crime Laboratory, a letter dated March 13, 2013, to the Division of Criminal Justice Services, requesting an extension of their New York State accreditation. Their current accreditation expired on June 5th, 2013 for New York State. We have some gentlemen in New York City, Bob Jenna, Dan Cheswick from Suffolk County. Are there any questions for Suffolk County regarding the extension?
Is this the appropriate time to talk about these corrective action requests? Or just you want to talk about the extension?
Is it on the agenda later?
Yeah, I think that's coming up under the agenda. If we look under page 5 of the, sorry, no, wrong page number, but under old business, under item 7.
All right, so we'll get to that later in the agenda, Marvin.
So at this point, we're just looking at the granting of extension for them to come in compliance, and this will be an extension of the New York State accreditation. Okay, I'd like to make a motion to grant the 6-month extension. Seconded by Dr. Stodgick. All in favor?
Aye.
Okay. Okay, unanimous approval.
That takes us to our new business. The first item on there relates to a letter that the commission sent to SUNY College of Environmental Services and Forestry in Syracuse, dated February 27th of this year. I believe that's been provided to the commission members. There's a response letter received March 8th that was also provided. With that response letter was an email that I believe was sent from the administration to the faculty regarding the issue. Is there any comment, any question from commission members?
I think it's clear that the SUNY laboratory does not believe it's operating a forensic lab. Right? But I think a follow-up letter needs to go to the Syracuse Police Department to ask them what they think they're doing when they take whatever it is they're taking to this lab and borrow these instruments and run them and collect information. I only speak from personal experience where in the clinical lab world where people thought they went and borrowed equipment, even if it was a certified lab, but they went and used somebody's equipment in somebody else's lab, that somehow that was okay, even though that lab didn't have a permit. But they were doing it for clinical testing purposes. So we had to explain to the permitted lab, no, you can't go borrow machines in another building that aren't in your building, that aren't under your quality assurance, and call it lab work. In this case, it might be the opposite. The state police department running an analysis on something on borrowed equipment. Syracuse, no, excuse me. Syracuse Police Department, since we, so I think a follow-up letter might need to go to them that says it's come to our attention you're using instrumentation at. What are you doing?
Certainly some of the public releases that were put out. I think there was a press release put out by Senator Gillibrand It seemed to me, at least, to clearly reference forensic work being done. And there was one other public, either article or statement that escapes me right now. But clearly left the impression that something is happening there. We now have SUNY saying it's not happening by us. So I think your point is well taken.
They don't think they're doing anything.
It appears from the letter that SUNY sent that they were not aware that Syracuse Police Department was performing casework in gunshot residue analysis. But I was at a meeting, the district attorney and I had a meeting with SPD in June of 2011. They provided us a chart of 11 cases that they performed gunshot residue testing on evidence. They've testified in 3 trials, and one of those transcripts, or all of those transcripts, are very disconcerting. At least one of them that I reviewed, the person that testified does not make a distinction between primer and non-primer residues. He states numerous times that scanning electron microscopy is the only accepted method for gunshot residue target to muzzle distance determination. He also did this target to muzzle distance determination using that technology, which I'm not aware of any other lab doing that. And he was basing the distance that he determined on an ammunition type that he claims he could tell based on the elements in that he found in the scanning electron microscopy. He had no idea what type of ammunition was really used in the crime. He was just basing the distance on that determination. I think it's disconcerting.
Now, the person who's testifying these 3 examples, is that an employee of the police department or an employee of SUNY?
He's an employee of the police department.
He's the jack of all trades criminalist for the Syracuse Police Department. His name is Terry McGinn, and he's the de facto author of Broden's letter that went to Asclad Lab complaining about the Syracuse or the Onondaga County Center for Forensic Sciences.
In the testimony that you're referring to, does he indicate that he did this work, the underlying work that led him to his conclusions at SUNY, at the SUNY lab?
Yes, he does.
I think
that would suggest that the Syracuse Police Department is operating an unlicensed laboratory.
Let me just, one more. Is this a service that you offer at an accredited lab there in the county? If they wanted gunshot residue tests done, does your laboratory offer that testing?
Well, there's 2 different types of gunshot residue testing, primer residue and non-primer. Our laboratory currently offers the target to muzzle distance determination. A lot of this work that was done was previous to that.
I just want to clarify one point, too, just to make sure. You had said that for muzzle to target determinations, this person had testified that the only acceptable practice was scanning electron microscopy?
Yes.
For clarity in the record, scanning electron microscopy is not to be used for that method. It is used for primer determinations on someone's hand and on rare cases for reconstruction for looking at something, but it is clearly not the method that should be used for that. Clearly not. It is not the accepted practice.
One approach would be to write a letter, but I'm thinking the other approach would be to ask someone from the Syracuse Police Department to come in here and explain to us in person, what's going on.
I agree. This is beyond a letter. I mean, here are 3 cases where a defendant is charged, and this is proof in a criminal case that clearly, from what Brian and you have already indicated, is wrong. This is demonstrating a pattern of behavior that's beyond any measure of professionalism. I think that if they're doing this kind of work that's at a place
basically
that they should be
operating
doing,
an unauthorized laboratory.
I mean, let's bring them in.
What's the penalty for operating an unaccredited laboratory?
$2,500 a day.
Penalty not to exceed $7,500.
Well, I
Specifically for the lab director personally, right?
Personally, and
the personal fine, not an agency fine.
My thinking is we should write a letter, tell them that this has come to light, that this is our concern, and that we'd like him to come in here at our next meeting and explain to us what's going on.
And let's tell them the penalties for doing such a thing.
I actually have another suggestion, because I don't think that it's adequate to ask them to come in and delay. I mean, this is testimony in cases where people got shot, as Commissioner Murphy is talking about. I mean, we can't wait for that. We've heard we have situations that we've seen in public records about the same police department is not turning over bullets to the district attorney's office for analysis. So I don't, it seems to me that this is a custom pattern or practice that is, has to be enjoined because it interferes with the civil rights of defendants to get fair trials, and as a policy matter, it's not good for citizens of the community that are expecting trials to be solved. So I would suggest that we try to take this to, I think, I'm guessing, you guys probably know better than I, but I think the appropriate entity in the state to conduct this kind of investigation is the state attorney general. So I think we should write to the state attorney general apprising them of these situations and see if they have any jurisdiction to conduct an investigation.
I don't know that the Attorney General would, though, because we're not dealing with an accredited lab. We're dealing with a police department that's doing unaccredited.
What are you talking about? Civil rights.
But you could. The only entity that I've been able to think about.
Oh, you're saying the Attorney General?
Yeah.
I thought you were saying the Inspector General. My apologies.
No. I'm talking about Eric Schneiderman.
Okay. Now I know what you're talking about. All right.
I just feel obligated to explain to the Commission how this became an issue in Onondaga County. Deputy Chief Sean Broughton, who is, again, the author of the complaint to Askeladd Lab, which we've been advised a report will be coming out, and I'm not going to make any reference whatsoever to what happened in executive session. I want to make that very, very clear up front. But as Dr. Corrado already alluded, it came to my attention that some of my assistant DAs were using this individual, he's an expert in DNA, ballistics, trace, gunshot residue, target to muzzle, or muzzle to target distancing. Am I leaving anything out that he's an expert in? And in any event, we had a meeting, and in 3 cases, my assistants used him to testify about what you would be considered gunshot residue analysis. Everybody in those cases has been notified of what we're discussing about here. One of the cases was a plea bargain where the defendant pled guilty. One, the court refused to allow this individual to testify, and the third one was a trial where there was a conviction. And to let Barry and Marvin know, as well as everybody else know, defense attorneys are aware of the issues that we're discussing here. This was for a very, very brief period in 2009. Once it was brought to my attention by Dr. Corrado, I immediately brought staff in and said, absolutely not. Shame on me. They should have known that if they're working in a professional office that these tests should not have been done. Testimony should not have been offered. With that said, Deputy Chief Broughton, just a couple of months ago, provided to my chiefs of police, for reasons that don't concern you here, an alleged timeline of what his involvement was, and I'll just brief from it very, very briefly. He says in June of 2012, he received a call from Gina Bianchi, who is chair of the Forensic Science Commission. Congratulations.
Yes, I can.
Bianchi tells me that GSR cannot be conducted in an unaccredited lab, which was pretty good advice. Then he said, I'll get back to you. I'll get more info and call her back. Broughton claims that on June 21st, he called her back, told her that the DA's office had requested GSR in no less than 11 serious felony cases. That's completely not true. It's in 3 cases that I've already talked to you about. This individual has attempted to do GSR work in 11 felony cases. And then he claims that Bianchi told me she would call me back, and I never received a call back. I doubt very, very seriously that that's true as well. Then he goes on to a timeline about other things. So this is kind of piggyback with a situation that I'd like to just very briefly discuss in open session right now that Dr. Corrado and I are both facing. In March of this year, Dr. Corrado indicated to me that she was going to be conducting a corrective action involving a sworn Syracuse police officer who had been assigned to the lab back at the turn of the century. I won't go into the history of the Syracuse Crime Laboratory. I'm a very, very firm believer in the civilianization of crime laboratories. Syracuse Police Department under previous administrations was very, very resistant to that. So Kathy, for some time, had to operate under a little bit of a hybrid situation where she had both civilian and sworn police officers there. While the sworn Syracuse police officer was still there, he conducted an examination in 2002 and indicated that a projectile that he examined in a homicide case was not suitable for comparison. A quality control issue came up. A current firearms examiner in the lab examined that same projectile and found that there were obvious striations and marks on the projectile that are suitable for comparison. Kathy then began a corrective action, wanted to review a series of cases of this ballistics individual for SPD. As we sit here today, Deputy Chief Broughton refuses to turn over the gun in that case to Dr. Corrado so that she can test fire it and compare it to the projectiles from that homicide case. The homicide case resulted in a plea. However, that doesn't absolve my obligation, my ethical obligation to inform defense counsel, which I have done, nor does it absolve him of his obligation to get the test results from this gun to see whether or not he may want to challenge the voluntariness of the plea that his client entered. It exhibits an absolutely extraordinary lack of knowledge, lack of expertise, lack of so many things at so many different levels about how the system is supposed to work. I don't know what I don't know what I'm going to do. I don't know if I'm going to use a search warrant, if I'm going to use a grand jury subpoena, if I'm going to use some type of standing on Columbus Circle with a sign over my head. I don't know what I'm going to do. I've never encountered this in 35 years in law enforcement. And if anybody's got any ideas, please share them with me today or privately later on. But I want the commission to have an opportunity to understand that when you say, well, we'll send a letter or we'll tell them to get it right. We've been trying this for 4 years to get these guys to a table in a room and start behaving like adults. And so far, we haven't got their attention.
I want to amend and expand on your motion, Barry. And what I would propose is that we make a referral to the Attorney General, but we wait until we get the Inspector General's report, and then we refer to the Attorney General the material in the Inspector General's report, the material regarding the unauthorized testing, the material that DA Fitzpatrick has shared with us just now about the bullet, plus any additional material that he supplies, and that we refer that to the Attorney General for whatever action they deem appropriate. But in addition, as a commission, I still think we should send a letter to the Syracuse Police Department, first of all, spelling out for them that they're not to be doing unauthorized testing or operating as a laboratory, and that, to the extent that that has been happening up until now, it's the expectation of the commission that it will stop immediately. And secondly, demanding that they appear before the commission at our next meeting to, one, tell us what's currently happening in that regard, and secondly, to explain what, if anything, they've done in the past, so we can determine whether or not there's been any inappropriate conduct which would result or which deserves sanctioning.
I just like the chair.
I think there's a problem trying to bring an entity which is a police department before the commission. I tried 2 years ago to have the commission send a letter to the 62 district attorneys about their discovery procedures on lab reports. Bill Fitzpatrick opposed that. The commission upheld it on the grounds that the commission had no jurisdiction over district attorneys' offices. In this instance, the second reason not to do anything with the Syracuse Police Department, let the AG handle it, is they're not operating a lab. They are going to a place that has laboratory equipment and using that equipment, running tests, and then going into court to testify. So if it were me, I would support the motion to have the AG, with all of the strictures that you've announced, have that information, and then send that letter. But I would immediately send a letter to the one entity that we do have jurisdiction over, and that's the State University ESF. They are a laboratory, and whether they know it or not, and I'll assume for the moment they don't know what's being done by the police department when they take the tests and then go into court, this commission can say to the State University ESF, you cannot operate a laboratory that's unaccredited or let your equipment be used for that purpose. That's certainly within our jurisdiction, and they're violating the law. Now, if they didn't know it, then this letter puts them on notice. And I think a copy of that letter to the ESF ought to be sent to the AG as well.
Marvin, as to your point, I think I don't know whether or not we ultimately have the power to compel the police department to come in, but we can certainly ask them to, and we won't have to cross that bridge until they refuse. Now, I think one of the distinctions here is that I don't think there's any allegation that any of the DAs were basically, running a rogue or unaccredited lab. And I think that, the information we have in front of us indicates that that's what the Syracuse Police Department is doing. That, they're taking equipment, they're doing tests, forensic tests, they're going into court and testifying to the results. As a commission, what power do we have to deal with people who are running rogue forensic labs in the state?
Well, I think that I support all of this, and I support what Mike said about asking them to come in. And in addition to that, I think, what Marvin said about sending this letter to the, ESF?
State University.
State University, just expressing our concern about it. And I would add what Brian and Kathy have said about the unreliability of the testimony. I think we should put in the letter that it's come to our attention that questionable testimony has been used. And frankly, I think what Bill is doing is exactly what we want prosecutors to do in every instance where they discover that testimony has been offered that is not scientifically reliable, and he's pursuing his ethical duties and bringing it to everybody. And our commission may be limited now in our jurisdiction over police agencies that are not laboratories, but we're not limited in our bully pulpit authority to send letters to the appropriate agencies, the Attorney General, or to bring the police department in and let our views be known, because this is wrong. This is really bad stuff.
I think there's agreement on that.
May I be recognized by the
I think
chair?
we've got two people who want to speak, so whichever order is fine.
I just want to advise the chair and the commission that under my traditional NYSEG authority, the State University is under my authority. And based upon what I'm hearing today, and I just received this letter and I reviewed this letter today, and the information that's just been provided as I'm sitting in the audience, and I don't normally in a public setting indicate an investigation, but it really warrants my NYSEG authority to intervene and conduct an investigation, at least relative to what SUNY knows, the grant that people are operating under, what they know, what's going on, all the questions that are being raised by this commission. So I'm telling you, under my traditional NYSEG, I cannot sit here without opening up an investigation. So I want you to be aware of that. I know you have a motion on the table, but you need to be aware of that.
Would it be your request, do you have any request with regard to the portion of that motion that asks us as a commission to send a letter to
I would ask
someone?
you not to send anything.
Okay.
So I could dispatch investigative counsel Hagan right now.
To the college.
To
the college.
Would it be fair to say that that would not, that request would not have any effect on a decision by this commission to make a referral to the Attorney General with regard to the Syracuse Police Department? You're asking us to not send a letter to SUNY.
May I ask you for a couple of days, and I will advise the chair?
The only dilemma here is that a couple of days for the commission means we don't get a chance to act again until June 26th. So I suppose one thing we could do
And I'm asking
is,
you to, I would ask for you to hold everything in abeyance so I can conduct an investigation.
Well, the other suggestion I was going to make is that we could, I see these as two separate but related issues. And, I very much appreciate what you've just said and what you are going to do, and I commend you for doing it. No matter how that turns out, though, unfortunately, I don't see it affecting, a real festering problem or potential festering problem, that has been dropped in the commission's lap with regard, and this is by no means anyone's fault. It's just a reality of how things are going to work out. Even if, you pursued that as vigorously as you could and everything went the way it was supposed to, it's not going to wind up really having any effect on the Syracuse Police Department with regard to a number of these issues. So as a commission, do we sit and wait until June 26th and do nothing on those issues with regard to Syracuse, or is there a way, without compromising your investigation, that we could take parallel paths?
Again, I'm in a public setting, so
yeah.
Let me just say, we're not speaking directly to this case, but cases in general. As I'm proceeding in an investigation, if it warrants me to notify my prosecutorial partners, I do that immediately.
Could we make
and I do
motion?
that as a matter of course. DA sitting at this table, the Attorney General's office, I do that as a matter of course. I don't wait to the end of an investigation either. As information comes to me, I reach out to my prosecutorial colleagues in order to commence actions. I have jurisdiction over the State University, the College of Environmental Science and Forestry. Obviously, if I'm finding that there is violations of grants, there's operations of a lab, things of that nature, obviously I have to respond and do what I need to do immediately.
If we took I'm sorry, go ahead.
So we could amend the motion to simply say we are saying we do want the letter sent to the college saying don't test, and we want the collection of all material for the referral to the Attorney General, pending your communication with the Office of the Inspector General, so that she can initiate the investigation and let you know whether we need to hold off 5 days or go ahead, or when we can go ahead.
And that way we wouldn't have to wait till
Right. That way we don't have to wait till the 26th. The commission has said, yes, do it, but we're just deferring until you have further information.
All right.
There is other action that the agency could consider, and that is notice of hearing, statement of charges against either of these entities. I think we defer now to the OIG for the operation of the Scofflaw Laboratory, based simply on public testimony. The person said, I did it, and public documents that say it's been done. I mean, this person has said he tested evidence in 11 cases. He operated. Now, Marvin, just so you are clear, borrowing instrumentation, even if it's located somewhere else, and using it for analysis is operating a laboratory, even if the entity who owned that instrumentation was not operating a forensics laboratory. Fine line, but...
I agree.
Okay.
I guess I would, my sense and my impression here is that we should probably hold off on the second part. I think your first suggestion is a good one, that we put a motion, we have a motion on the table, we'll refine the motion, we'll vote on it, but the motion will be conditioned on the Inspector General saying, yes, I'm okay with you making the referral.
Thank you.
And that way, if it's 3 days or 5 days, we don't have to wait until June 26th. As to, the notice of hearing, just to me, that seems to move too closely into what the Inspector General is doing, and I think we ought to wait and give her the chance to move forward. And, we could get a report in executive session at the next meeting if it's appropriate. So I guess what I would do then, kind of trying to refine all these motions and maybe wrap this up, is propose that as a commission, we make a referral to the Attorney General with regards to the inspector, any report that may be issued by the Inspector General. In addition, the material that DA Fitzpatrick just reviewed with regard to the gunshot case and the inability of the DA in the lab to get the gun, to do the testing they need, plus any other material that the district attorney and the lab feel is appropriate to really, give context to the events that we're dealing with, and that material be referred to the Attorney General from the Commission for whatever action, if any, the Attorney General deems appropriate. But a condition of this motion is that we will not make that referral until the Inspector General indicates to us that she feels it can be made without compromising any investigation that she's conducting. Did I make it through that all right?
For clarification purposes, we are or not going to send a letter to Cindy ESF?
I believe we've been asked to hold off on that, and I think that's reasonable. So we have a motion on the table that I just made. Any count or any discussion or any second?
A second.
All right, any discussion? All right, all in favor?
Aye.
Anybody opposed? All right. Okay, we have one abstention.
How can it be the same entity?
All right. I'm sorry.
Well, maybe it's good.
Commissioner, unrelated, and not wanting to step on the IG's purview, when somebody is operating a lab, one of the problems that we have is we can't allow it to continue. It sounds like locally they can't fix this. The cease and desist order, jumps out at me as a warning. The commission doesn't have to wait necessarily a long time, and it doesn't even have to accuse. So to the extent that they said, including a copy of the relevant statute and regulations with respect to the operation of laboratory procedures, to the extent that they're engaging in any of the following activities, please cease and desist. It's an idea that I definitely don't want to step into the Inspector General's lane, but one of the things I think that we've learned over time is that when we wait, when we know something bad is happening under our nose, we look foolish through hindsight. So I would suggest that as a possibility.
No, I think it's a good suggestion. My personal sense is that we should give the Inspector General a little bit of time, and kind of take this meeting at a time. But I think that is a good suggestion. If we have an indication in our next meeting that this conduct is continuing, I think that's certainly a very good suggestion. Thank you. All right. We have more new business. Our next piece of new business relates to proposed amendments to Part 6190 and 6192 of Title IX of NYCRR. There was a memo dated March 4th with regard to that. As I understand it, the proposed amendments basically deal with 5 areas. The first is to do away with provisional accreditation and rely on accreditation based upon evaluation of mock cases. The second adds a requirement that laboratories notify the Commission within 3 business days of a change in management, as opposed to, I think it was the 30 days that we previously had, which resulted in us reading about lab changes in the newspaper. The third one is to clarify the regulations regarding labs using YSTRs and mitochondrial DNA testing in cases of potential indirect associations. The fourth is the period of New York State accreditation should be defined consistently for DNA and non-DNA labs. And the fifth would be to allow the Commission or the subcommittee through the chairs to issue notices of violations to labs that must be responded to in writing within 5 business days. Is there any discussion or comment with regard to the amendment or the amendments?
Yes, I do. Did everybody receive this short email that I sent on April 9th regarding the use of YSTRs and MITO in the initial application phase of the scheme set out on 6192, the partial match provision? Did everybody get that?
Yes. Yes.
Mm-hmm. Okay. All right. But my proposal, hopefully it will be short, if not, is that we not we send this back to the DNA subcommittee. I attended the DNA subcommittee the other week when this was being discussed, and it's my understanding, Brian, correct me if I'm wrong, that the subcommittee is now going to first be provided the data on, I think it's 50, how many is it, investigations that occurred pursuant to direct association?
It's approximately 59 at the time.
59, of which I understand 3 are ongoing and 56 have proven not to be, not to have resulted in any arrests. And the underlying data from those cases has not been provided to the DNA subcommittee. And I think that in order for us to make an assessment here of how these regs should be redesigned, it would be helpful to have all the data. In particular, I further understand after having some conversations yesterday with Brian that the 8 different DNA laboratories within the state each have a different method for deciding when looking at the 10 loci from crime scene evidence as to whether or not to contact police or district attorneys about pursuing additional investigation. The proposal before you is that they should be entitled in the first instance to do MITO testing or YSTRs before making the request for further investigation. That's what I understand. My suggestion is simply to punt this back for the moment to the DNA subcommittee so that they can get all the data and start making some analysis and suggestions on what all this shows. It was plain to me that there were numerous comments, and I think the record will be clear, that the DNA subcommittee, the scientists there were under the impression that New York State engages in familial searching, and that the question before them is how to best go about doing familial searching, and what things could be put into the toolkit of the laboratories to do familial searching. I actually don't disagree with the notion that what we're doing is in fact familial searching, but if you go to the website of, I think, DCJS and the FBI, everybody is saying we don't do familial searching. That what's going on here is an inadvertent, accidental discovery that there may be an indirect association. So before we move forward, what I think is a pretty important policy issue for the Commission and for the legislature, I think it might be useful to just send it back to them and get more data. Personally, I think that what we ought to do is give serious consideration to all of this, and we may wind up with a system of pursuing partial matches or quote-unquote familial searching under judicial review with the sunset provision, with experts looking at all of this. This has been proposed by a number of different entities and commentators in the field, but I don't think we can make any judgments here until the DNA subcommittee actually gets all the data. So I would ask that we not accept this as a binding recommendation, and I think everybody agrees we have the authority to send this back to them until they actually look at all the data. That's my motion.
Thank you. And just to be clear, I think I omitted to mention it during my introduction, but this does come to us from the DNA subcommittee as a binding recommendation. And Chief Blasky, to indicate.
I apologize. I had to step out, and I came in about 3/4 of the way through. So in terms of the regulations, what I would ask the Commission to consider is not precluding a police department from asking for the likelihood ratio. I think I'm using the wrong phrase. And not precluding a laboratory at the request of a police department in doing the YSTR. So I agree with the Commission that you may have to debate this more. But I think what is driving partially the, no pun intended, the regulation is that there may be a concern that releasing certain information to do the YSTR is in violation of the statute. So I'm just looking for a little help and not have to wait much longer or any longer. Would be great if I could get what the, in other words, what is that likelihood ratio? It's my understanding some police departments get it, some police departments don't, we don't. And that we could ask that a YSTR done and a laboratory not be precluded from doing it. So I don't know, that may be totally consistent with what you're speaking about, Barry.
No, it's not.
Now, actually, if I could just interrupt for a sec, I think what I'd like to do, just for clarification, what we're talking about here is there is no discussion of the partial match policy on the agenda. What we have is a regulatory package that's in front of us, and the majority of that regulatory package has absolutely nothing to do with partial match. One very small piece of that has a minor change to a policy that even if we sent back to the DNA subcommittee now, still we'll be doing partial matches. So by this commission sending it back, it will not stop partial match from proceeding forward in the state of New York. The change I just have to clarify, Barry, then you can respond to it. So right now, there currently is a policy in the state of New York that the DNA subcommittee and this commission voted for, and granted it was a contentious vote, but there was a vote. So there is a policy within the state that is being done, and sending this package back, this regulatory package, will have absolutely no bearing on that. That will still continue to march forward and go exactly as it is. What's proposed in this little changeover here, right now, the DNA laboratories have the option of doing a Y testing. The recommendation is being made that they should do Y testing. And the reason for that is because it will further exclude potential suspects. I think the statistic cited in the DNA subcommittee by the chair, Dr. Ballantyne, is approximately 99.9% of potential indirect matches will go away with the addition of YSTR testing. So this is actually adding a safeguard to prevent further people being dragged into the net. So it's just the important parts to put here is that this entire regulatory package is not the policy of partial match, which is not before the commission now. What we're looking at here is a binding recommendation from the DNA subcommittee, which basically says, this is what we have. The members of the DNA subcommittee felt it was important. The reason they said should and not must is there's not always possibility of doing Y testing because there might not be enough extract or sample. But it's one of these situations where they said it. But regardless of if this commission sends it back, this state will still continue to do partial match testing. So I hope that clarifies the issue. And again, there's no issue about policy.
It doesn't clarify the issue. I had a long conversation with you to make sure that we had clarity about it. In fact, it obfuscates the issue. Let's be very clear. I'm not asking for the whole thing to be sent back, just this one provision on the Ys. I don't believe right now that Phil is precluded from asking the lab to do Ys or MITO testing in an appropriate way. But the point is, I attended that meeting, and it's very, very clear. We had to do a flow chart of this regulation to understand what was at issue. And Brian, you and I went over it yesterday, and you told me, correct me if I'm wrong, that each of the different laboratories, and I think that this is one of the issues that the chief is talking about here, each of the different laboratories, the 8 different laboratories in New York State, has a different threshold for deciding when they are going to ask permission of a police entity or a district attorney to pursue the partial match procedure. And what
that's
has
not
to
an accurate
happen
representation of our conversation. But what I said is that there are differences within the state. There are certain laboratories that have internal policies, and again, this is where we went to it, where they will just not pursue partial match unless it's a homicide or rape case. So that is their option. They have the option when they see the data to not pursue it. So the thing that you're representing is different policy, different procedures or statistical thresholds. That's not correct. What it is different laboratories have elected based on their workflow and customer conversations if they wish to pursue that, which is their right.
But whatever it is, it's not apparent on the face of the regulation or whatever it is. I think that it would be of assistance to the DNA subcommittee and to this commission and the public as a whole to know what the policies are. of each of the laboratories before they will ask a police department or a district attorney to go down the road of the partial match investigation. I think we have to have all the data. They don't even have the data on all the cases. I am totally sympathetic to the New York City Police Department's desire to have all the data that they are legally entitled to in order to decide whether to pursue an investigation. Many of us felt that the lack of scientific clarity here on the statistical thresholds or even the number of markers being used was going to inevitably result in wild goose chases. That appears potentially to have been what's going on, and it's a waste of resources. What I think we need to do, and this is the reason I'm asking that just this particular provision with respect to the use of the YSTRs and MITOs be sent back for further consideration. It's my understanding that the DNA subcommittee is going to be getting this data and can start going through an analysis of it, and we'll have some better understanding of what a sensible policy is. We don't even know what all the labs are doing.
And that's exactly the point. This isn't a discussion of the policy.
I'm proposing to table it.
Barry,
Send it back to the commission.
Barry, let me ask you a question. You and I were on different sides of the issue. How many years ago? I can't remember. It seems to me that if what you and I agree is familial testing is going to continue, that it would be good to have this safeguard that would eliminate a lot of what you refer to, and properly so, as some wild goose chases, and then revisit the whole issue. Why not ask all 8 DNA labs in the state, what are your policies with inadvertent / familial matching? What success have you had? Check with the police departments. Did you expend a lot of energy, chasing a false lead? But I'm just confused why you would, not confused, I just think that you would be in favor of this safeguard and then do the research that you're asking for.
Wait, let me just add one thing. Am I correct in understanding that in this year the DNA subcommittee is looking at the general issue of partial match and whether or not, what's going on and whether or not there should be changes?
Every 2 years, they are charged with reviewing the policy, and they're currently doing that.
All right. So that's separate and apart from this change to the regulation.
Correct.
All right.
No, it isn't, Mike, and that's
All
my
right.
whole
So we have a
point.
difference of opinion on that.
Well, no, I don't
Yes,
think
we
there's
do.
any
I feel
difference
one
of
way, you
opinion.
feel another.
No, don't get me wrong. Don't get me wrong. Let's just talk about facts. I attended the meeting for this very purpose. I absolutely agree with what Bill Fitzpatrick just said. My proposal is simply, at this point, don't adopt this particular regulation yet because they are they're in the first instance getting all the data. Frankly, one of the scientists on the subcommittee, Ken Kidd, said, why are you even going to bother if you're really going down this road with Ys? You should get what they call single nucleotide polymorphism, SNPs. It's going to be a waste of time doing anything less than that. My point is very simply, this particular proposal is being put forward before, and this is a fact, the subcommittee has all the data from the 59 different efforts to pursue partial matches. And by the data, I mean not just what efforts were being made investigatively, but what scientific data triggered the initial request to do it. And I think we need all that data in order to make an appropriate evaluation of what the policy should be. And frankly, Bill and I actually, I think we're in some kind of agreement as to what should be done with respect to the partial matching, and that is that it would be good, in my judgment, for the legislature to actually consider having a warrant requirement and a committee to review each instance where there is going to be an effort to do what is really familial searching to see how effective it is. Just to be clear, many of us who were worried about this policy said in the first instance, and it's not just me, it's John Butler, who is the NIST expert on DNA, National Institute of Science and Technology, has said that proceeding in the fashion that the regs do right now is inevitably going to lead people on wild goose chases and doesn't have any real discriminating power. So that's what we predicted. That's what appears it has happened in the first 59 investigations. And we don't even have the data as to how that happened or what happened. And so that's why I'm just simply saying, don't take the so-called binding recommendation right now, send it back to the DNA subcommittee, which was promised at that last meeting to have all the data about these indirect association and partial match investigations put before them in I think executive session to some extent, because it does require disclosure of an ongoing investigative material. That's my proposal.
And I guess I look at it a little differently. The DNA subcommittee at their last meeting voted to send this to us on a binding recommendation. So while they may have felt that they didn't have all the information they wanted for the overall review of the partial match policy, I've got to presume that by voting yes and by sending this to us on a binding recommendation, they felt that they had all the information they needed to make that decision. So that's why I say I think you and I disagree on that point.
Well, you weren't there.
Welcome to Unified Conferencing.
Bye, Barry.
You are the first person to join the conference.
When I read this, my first reaction is, I have no idea what you're talking about or why. Are these regs published with the equivalent of a regulatory impact statement that it would explain, as Brian attempted to do, why having YSTR data would help weed them out?
Right. After the commission approves them, they're published in the state register.
Okay, and that impact statement would have all of that information about why the change is being made.
Correct.
I'd like to suggest that in the future, when the commission gets them, it would be nice to know why the changes are being made. Because then I think some of the... Wait a minute, Barry, you had a chance.
I'm sorry. Go ahead.
My other question was, I'm not aware that all 8 of the state labs are authorized to do, they may all be doing YSTR, but I don't think they are, and I don't think they're all authorized to do mitochondrial DNA. They don't all have the technology yet established and validated. So are we really, so now it's a technological capacity question. They should do it, but if they're not approved to do it, who's doing it? Are they all coming to the state police lab? And do they have the capacity? And does that get into other issues? So it was not clear to me, one, that all of the DNA labs have the technical capacity to do this. I'm a geneticist. I ought to understand why these are being added. And I really didn't understand what the value of doing these if you had 10 of the other STR markers that were matches. We're looking at 10, not 13, right, on our partial match policy, and those 10 have to match just to identify a possible connection, and then you have to do the investigation to figure out, and I absolutely agree, anything we can do to limit the wild goose chase investigations is really important, but not having that explained, as you said, if it's really true that there are 59 of them, Barry, and in 59 of those YSTRs would have ruled out 58, then that's really important data. Or is it just a statistical estimate? But so I was just very confused, and I don't feel without having the equivalent of the regulatory impact statement that says why these changes are being made, I don't know what I'm voting for. Even though the DNA subcommittee feels they had enough, I unfortunately didn't get to their meeting, so I don't know.
I was there, and the first thing that happened is that they were given this proposed regulation to vote on, and then they had a discussion about what the data could be or should be or what they needed. So, Mike, whatever you are presuming, believe me, is not a fair presumption.
Barry, did you just represent that they got the regs for the first time in the meeting?
No. I said
okay,
the
good.
order of the voting. The order of the voting is first they voted that we should do the WISE and the MITO, and then they went about trying to ascertain other requests for data. My objection at that time is, as scientists, you should first have the data and then decide on the regs. And there is a disconnect here between what the scientists are asked to do and the policy. My point very simply is exactly what Ann's talking about. Look, Ann's a geneticist. I have some expertise in DNA testing. It took forever to look through this and figure out what was going on until I could determine that there were different policies from each different laboratory about what they were going to do in the first instance. The way our regs are set up is that first the labs have to get police agencies and the DAs to agree that they will pursue an investigation, and then they go to the DNA data bank to get evidence, to get the identities of the individuals, and then they will go about, if necessary, or if it's possible, doing YSTRs and MITO at the end of the process. I'm not saying that in some smart world we might want to not just do WISE and MITO, but SNPs or something else if you really want to get to the bottom of it and make sure that the chief of detectives is not doing 56 investigations that go nowhere, or however many it was. But let's just do it right and understand exactly what we're doing. And in order to do that, we have to get the data. And so my motion is a very, very simple one. The DNA subcommittee didn't have the data. It should be sent back to them so they can actually have an informed, intelligent evaluation of all of this. This is not a trivial matter. This is a very important issue.
Steve, you had something you wanted to say?
Just to fill out the historical narrative, and some of this is all caused by the abundance of caution on the part of the state police. Started working on this issue in 2005. There was a 2006 FBI legal bulletin with respect to interstate partial matches. As we all know, we've worked on this issue for quite some time. The reg was enacted pursuant to Hoyle. At the time that the reg was enacted, and I've gone to just about all of the DNA subcommittee meetings, Barry, at the meeting prior to the one that you attended, what happened is we developed our ability, we fully validated our ability to do WISE on the data bank side. The statute has arguable ambiguity to the extent that it says STRs, including YSTRs, but it also says that when the EMR and the EKR don't reach the expected ratio, go to WISE. The consensus, unanimous, of the subcommittee was we have to be doing WISE. WISE, there's a compelling scientific reason to do WISE, and it was at my request of DCJS that even though arguably we could do WISE under the existing statute, maybe to make it a little bit more clear, we would do that. So the vote, the meeting prior to the one that Barry's referring to, the group unanimously agreed, of course you do WISE. There's no scientific reason not to do WISE when you can exclude 90% of wasteful knocks on the door. So to a certain extent, my attempt to get clarification set some of these things in motion. That being said, the reg is the reg. It's on the table. Things can happen downstream, and I think there's enough information before this group to vote on it, and it's not going to be the end of the issue.
All right. I think unless someone feels otherwise, I think we've debated this sufficiently. We've got a set of amendments that cover 5 different areas in front of us. My understanding is to come to us as a package as part of the binding recommendation. I think my understanding is we'd have to consider them as one. So I would make a motion that we accept the binding recommendation of the DNA subcommittee with regard to these regulations.
Second.
Point of order. Point of order. That's not so, Mike. The commission under its bylaws operates pursuant to Robert's rules. And the motion is totally in order to sever out from any package and consider each of the items either ad seriatim or to consider the one section that Barry is addressing separate from the rest of the package. And that's my motion. Is that the one point that Barry is asking us to take a look at, that we vote on that separately from the rest of the package.
I guess the problem I have, Marvin, with the Roberts Rules point is that we have a binding recommendation from the DNA subcommittee. It's not, if someone made this motion fresh and it didn't come to us with any history, I would tend to agree with you that there'd be nothing to stop us from voting on them one at a time, taking one out. But my reservation is that we don't have a binding recommendation from the DNA subcommittee giving us 4 things. We have a binding recommendation giving us 5, and unless someone can point me to something to the contrary, my understanding was our choices with regard to that binding recommendation are 1, to accept it, and 2, to send it back.
Isn't it binding only? Why is the DNA committee issuing a binding recommendation
Because in theory,
mock cases?
All of these. Because they accredit DNA labs, so on any issues of accreditation of DNA labs, they're issuing the binding recommendation.
So all changes in the regulation pertain only to DNA?
No, the mock cases.
But 8 of the labs are DNA labs. So
they apply to both.
They apply to both.
The notification with regard to the director applies to both.
They don't find us other than the DNA. Would be I would agree with you.
Yeah.
And Mike, the fact that the DNA subcommittee makes a binding recommendation does not bind the commission. If you read the bylaws of the commission, the term binding recommendation is unfortunate. The rest of the bylaws make it clear that you can, it's up to the commission to decide what to do with the recommendation.
That's true. You can accept it or send it back to the DNA subcommittee. That's true. So the motion is to accept it. So you can vote on the motion, and if you don't accept it, it will go back to the DNA subcommittee.
Well, except that Barry had already made a motion. If he has a second, we have to vote on it, don't we?
All right. His motion wasn't seconded, but I guess it doesn't matter what.
Marvin second.
All right. So your motion is to send the whole package back?
No. Our motion is.
All right. Where in the bylaws does it say we have that third choice? As I'm reading it, and as I understand it, we have 2 choices. We can accept it, we can send it back. I don't see where it says that we can pull apart a binding recommendation that comes to us from a DNA subcommittee. You're right, we don't have to accept it, but our choices are accept it or send it back.
No, Mike, it's just common sense. If they send us 5 recommendations, it doesn't mean we have to accept 5. We can accept 4, which is really what I'm proposing, and send the 5th back if we want. There's nothing in the rules that says we can't do that. In fact, the obvious
She doesn't think we have the authority to do
rules is that we can do that.
I don't.
Do we have the binding recommendation? I'm not seeing how it's stated.
It's not in the binder, but we have it upstairs, and it's for all of them in toto. It's for all of the regs together. It's not for specifically the partial match one. Because what happened is those binding recommendations, the management notification, the doing away with provisional accreditation, should we send this whole thing back, theoretically, they only apply now to the 8 DNA labs and not the rest of the 22 labs in total. So what you do is we now create 2 standards within the state of New York.
All right. I'm not comfortable voting. I think because they came to us as one package and a binding recommendation, my reading is that we have 2 choices. 1 is to accept them, 2 is to send them back. If we send them back, we could ask them to send the 4 of them back to us in one package and deal with the 5th one separately. But I don't think we have that option right now. I've made a motion. Barry's made a motion. Do you? Go ahead, Barry.
I think that's very unfortunate, Mike, because I think you definitely have the power and the jurisdiction to consider 4 except for and send the fifth back. There's nothing in our rules or in Robert's Rules of Order or anything else that prevents that course of conduct. And the reason why it's so troubling to me is that, in good faith, we're raising a serious issue. And, it would seem to me that, nobody wants to not accept those other 4 recommendations, which, represent past business of the committee. And the one thing that requires further evaluation and research should not be held hostage, to the other things that we want to do. So I just think that is not good sense under these circumstances. You're the chair. I can't stop you, but I think that that's wrong.
All right, your motion, Barry, was to send back you want one of them sent back, and as I'm reading the rules, that would require all of them to be sent back. So obviously I've made a motion to accept them. Is your motion to send them all back?
No, my motion is to send back only number 11.
All right, we'll vote. Is there a second for your motion?
Yes, second.
Okay, it's seconded. As a chair, I'm indicating to the commission it's my opinion that because they came to us as a binding recommendation, we don't have the choice, that we're not authorized to do what you're asking us to do, but we'll put it to a vote. And I'll tell people I'm going to vote against it. One, because I think it ought to be accepted, but 2, because I don't think we have the authority to sever these out. But everyone in favor of Barry's motion to send back the one portion subdivision 11 that deals with the partial match testing. All right, we have 1 here. We have 2. Marvin, you're voting yes? All right, so that's 3. Everyone opposed to that motion? All right. So that motion fails. Now I'll put my motion on the table. I would move that we accept the binding recommendation of the DNA subcommittee with regard to these amendments. Do we have a second?
I second.
All right, all in favor? All right, all opposed? All right, so that carries. All right, our next item is with regard to the DCJS annual reporting regarding New York State Laboratories. Brian?
Essentially what we have here is there's documents from all the laboratories representing the annual reporting. Some laboratory directors we have here, some we have available. If there's any questions about anything that's part of those packages. Some laboratory directors, unfortunately, are unavailable, so if there are questions, we can reserve on them and approach the laboratory director. So regarding the packet of annual reporting, does anyone have any questions?
Now, is this the time that we can discuss Peter's memorandum with respect to the hair comparison survey?
I think that's the next item on the agenda, Barry.
Okay, all right. Never mind.
Marina, I want to ask you a question, and it might completely be that I don't understand, but it seemed when I looked at all the majority of the tox labs, when they had issues with proficiency tests, they provided documentation of that they looked into it, and they tried to determine the root cause and perhaps look at the affected casework. And I'm not sure if I just didn't understand what your information was, but when I understood your information, it didn't necessarily indicate that. Was that done, the root cause, and look at casework, or?
You mean my personal
I'm sorry,
my lab?
the information from your laboratory.
Well, we did include all the corrective action memos and what we did.
Okay, so maybe I just don't I just didn't see where it said, if you knew what caused the issue and if it would have affected casework or not.
Oh, you wanted to see that particular sentence?
Well, I guess when I was looking at the other tox labs, it seemed like they all included all that information. I don't know.
Well, it depends on the issue. Okay, was there any particular particular
Well,
one that you're questioning? It would be.
well, like and again, I'm not a toxicologist, so I might not understand this, but the one instance, it looked like the way it was extracted, you didn't, you missed the analyte because it was extracted when you tried a different type of extraction, you found the analyte. So I guess my question is, do you then say, from now on, we're going to employ that different extraction method, or, I don't know if...
Well, I thought we did. I'm sorry. Again, that would have been, the way that we do it is, it would have been in the corrective action memo. But you obviously did not see it.
Well, maybe, I guess if you're confident that you did that, then that's fine. That was really my question. I mean, I just didn't happen to see it. So if you're saying you did that, then that's fine.
I'm sorry. Could you tell me which one, Kathy? Because I'm a little lost here.
I think it was the first one, the one CAFT VT06, Serum 2011.
Oh, the tramadol?
The metabolite, I guess, the tramadol metabolite.
Yes, well... Maybe it's not explained well, but...
Maybe let me rephrase the question. When you're looking into these proficiency test results, you do determine a root cause and see if it could have affected casework. Is that routine?
No, but what we did do when we received, at the time when this was received, we were using a different extraction method, which is why we were not detecting the metabolite. Since then, we switched, and now we're detecting it, but I'm sorry, I thought it said that, and you're absolutely right. That should have been included. It should have been included that now we're using a different method. You're absolutely right.
Okay.
So we'll make that clearer.
Okay, I just comparing it to the other labs, that's all I was curious. Thank you.
Okay, sorry about that.
Other questions?
Yeah, I have a general question to OFS. I mean, it's an awful lot of material. Once again, we appreciate all the effort in compiling the documentation, but it's presented in a way that is not easily assimilated to draw any conclusions or to formulate questions. And one issue that's always very important to me are instances of recurring errors in proficiency testing. And there was no way for me to assess in reviewing these documents whether, in fact, laboratories had recurring errors. And there are significant consequences to recurring errors.
Sorry to interrupt. Essentially what happened is when we reviewed the data from all of these, the one recurring error we see is essentially just in Tox Lab at this point, and it might be a policy thing that we need to work through, but essentially it's false negative reporting. That, the false negatives are all over the place. As to, and it doesn't seem to be a consequence. And part of that is I think ABFP does not have a proficiency test review board, but there's no mechanism to actually look at it. Now, some labs have a limit of detection that's here, some labs don't test for something. So on proficiency tests, they'll routinely miss things. And currently the way the standard is written, that's not something that's a penalty. So I'm not sure it's necessarily at the level you're talking about showing a systemic problem, but I think not for now, but I think for a conversation for another time would be to kind of look at a way to tighten up the systemic false negative issues that are coming out. And again, without going into data, but you can kind of see that here, on this sheet, every single time there's a false negative, it's in yellow. And I apologize for the guys in New York who might not have a good view. So that was some 2012 data I was still processing. But there's a significant number of false negative reporting and tox stuff that doesn't appear in the other disciplines. So, as I said, it might be explainable. I think it's something we're starting to focus in on. Okay. But it's not systemic to the point where someone is, as I said, we're working within the discipline to try and get to the root of it. But it's not that, there's a DNA profile that's consistently being missed, a firearm that's consistently being misidentified. It's something that might be a cost of doing business. I'm not sure. We're going to approach it systematically to look and see the best way to try and deal with that. And again, you're a native tox person, so I think you kind of know the root of that problem.
Yes, what I was thinking too is if you have suggestions on how this could be presented in the format that you think would be better, we're open to suggestions.
Well, the burden shouldn't be on OSS. I truly believe that the accrediting programs and the PT providers should provide reports in a format that are easily understood by anyone who has to use them to make a judgment about a laboratory's performance. On the clinical side, it's an absolute requirement. If you're an approved PT provider, these are the conditions that must be met. And among those are readily identifying instances of unsatisfactory performance and the prevalence of those errors. So I hope moving forward that we have better control on PT providers and, requirements of them.
But isn't CAP a clinical provider?
Yeah.
We don't get that from them.
Because you don't participate in the clinical regulated analytes programs. Any program that is CLIA regulated.
Oh, we're not CLIA. Okay. Oh, that's a CLIA
standardized
report.
format. They review over 3 to 5 test events, and they identify across those 3 to 5 a laboratory's performance by analyte, by specialty.
Yeah, but we're not subject to CLIA.
That's right.
Yeah, but that's why we're not getting it.
I think the commission, the office, and laboratories would benefit by a better presentation of ongoing performance in PT.
And OFS is in the process of redoing the annual reporting.
Yeah.
And I think as we've talked about offline, some of the things we're going to start looking at also is backlogs through labs, how labs are managing their backlogs. There's other aspects. So we're looking at changing the format of the entire report. And at the last NICLAC meeting, we've actually talked to the directors about that as well. So the format will be changing and taking to some of your things in consideration.
So, Dick, for example, for your comment, for all of these tox labs that are using CAP proficiency tests, those are CLIA PTs, are they not?
No, they're not regulated analytes.
Not if they're okay.
No.
So even for those, CAP hasn't carried over their their CLIA standards.
In this instance, for the urine toxicology, no.
Okay. That's unfortunate because they would have the data system to be able to do that.
Do we get that for state alcohols? I don't think we get that either. New York State alcohol program.
Yeah, I'm not sure what's being provided in the way of
I don't
history.
think that's provided.
No.
Well, there is, no.
I assure you it is in the clinical and forensic toxicology and therapeutic.
So could you provide the accredited labs in the alcohol programs with them?
Well, I can inquire.
Because that would be a very simple one.
It might be a good idea because then it might be a good example for other
Right.
things as well.
I would suggest everybody take a look at the new Cass Sunstein book called Simple that was reviewed in the paper. Go back and look at Nudge because these are really, all this data is not sent in a form that directs one's attention to the matters of concern, as Dr. Kenny was saying. There must be a better way to do it.
Can I make a comment, please, about the toxicology?
Betsy Spratt.
Okay. Yes.
I know, Dr. Jenny, that you think this should be reported in a better format, but we look at over 300 drugs, and we don't get that same drug all the time. We may not get it for a year because of what's being presented to us. So for us to say, what did you do 2 years ago, that's important, but it's very difficult for us to show you that because we get so many different drugs, and metabolites don't always end up being reported even on our casework. Some of it is to see if we can even see it. So that's where things are changing in the field as well. So that's why it's difficult to get a constant report because we don't get every drug every time.
No,
We
I
never get
understand.
them finished.
I understand, Betsy. There had to be some creativity in the presentation of performance in PT, but there are valid groupings that could be made to judge performance for classes of drugs. I mean, there has to be a simpler way.
I don't think it's as simple as you would like it to be.
Something to work on.
Besides the formatting, which we're going to look to improve, are there any other issues regarding the workload surveys?
All right, our next issue is the hair comparison survey. This came from a request by Peter Neufeld. Unfortunately, Peter cannot be with us today. To some extent, I do think he's asked us to put this on at the next meeting, if I'm not mistaken, in one of his communications.
Well, no, but he's been texting me, and he sent a memo, and I'm prepared to make the inquiry.
That would be beautiful.
So, actually, his memo raises a very simple question that perhaps somebody can answer for us, and that is, how can the hair survey show that Suffolk County, which told us at the meeting that they weren't putting the disclaimer in the report, and then the survey shows that they say they did. So that has created some concern as to the validity of the survey.
And I think it would have to be Suffolk that could answer that question. So do we have someone from the Suffolk lab? I guess I would ask first, do you understand the question that was put on the table?
Yes, I do.
Okay.
My response to that question would be that the survey indicated a disclaimer/qualifying statement, and it's our position in the trace section at Suffolk County that we do include a qualifying statement, and that was the reason why we answered to that we've always done that. We never tried to say that we add a disclaimer. We have not added a disclaimer until recent changes pursuant to the CARS to our recent inspection.
Thank you.
I don't understand. So, just tell us in English. I mean, and I don't mean that in an offensive way. Lab report, and what would you say on the witness stand with respect to the probative value of an association?
What goes into our report is the statement that when we have a positive association, where we say that the comparison that the question and the known are similar with respect to the physical characteristics. Our qualifying statement is, therefore, the hair, the questioned hair, could have originated from the source represented by the known. On the witness stand, that would be the result of our examination would be that the hairs are similar with respect to the physical characteristics. Our qualifying statement, that would be that hair could have originated from the known. And in our introduction into the hair examination portion of the examiner's testimony, they explain that hair is an associative type of evidence. And they explain, through questioning as to the fact that hair is not a positive form of identification. Let me ask you this question. What got us here from the last time you were here is this. You had a manual, right? And in the manual, it said that hair comparisons are not the basis for absolute personal identification. That's what it said in your manual. It also said that what you call as a qualifying statement, that a Q1 hair with the known hair showed that they were similar in physical characteristics. Therefore, the Q1 hair could have originated. I assume what you mean is could have originated means that's the qualifier, could, correct?
Correct.
Okay. Now, regardless of whether you consider that a qualifying statement or not. The issue the last time you were here was that reports were issued that didn't have what you said you had in your manual, where it says hair comparisons are not the base for absolute personal identification. It had gotten left out. And the question that I had asked you, which I couldn't get an answer, was, we don't know why. So now, is it your response that you did issue reports that had in your all of your hair reports, going back to the 70s, the 80s, right up to now, the statement could, right, that's the first qualifier, and that you in fact put in hair comparisons are not the basis for absolute personal identification in the written report?
That's in the manual. We're not saying in the manual that we were putting that in the report. And in our opinion, that's a disclaimer. Now, we've since identified with that statement and are now placing that as a disclaimer. In the past, we've used the wording could have. It's our understanding that that was a qualifying statement. We never said in any of our reports, or then we never said in the manual, that we were going to put in there a disclaimer. But we now are including a disclaimer.
And just so I'm clear, because I understand what Mr. Doller said, on page 2 of car number 24 of 25, you now have a normal positive conclusion, correct? This is what you're going to say from here on in. Therefore, the question here is similar in physical characteristics to the known. That's one. 2, that the question here could have originated from the sources as represented by the known hairs. That's the second one. 3rd, or from another individual whose hairs have physical characteristics. That's 4. And 5, it should be noted that microscopic hair comparisons are not a means of absolute personal identification, which is 6. Those are now the way you're going to do it, correct?
Yes, that's absolutely correct.
Okay, now, here's my question to you, and this is what I don't understand. Whether we have a serious debate on what is a disclaimer, a blanket disclaimer, or a qualifying statement, clearly, when you issue a report that says the Q1 could have come from the known, and you consider that as a qualifier, and say nothing further, that conveys to the reader of the report, a lay judge, a lay prosecutor, a lay defense attorney, that there's an association, could. It could have come from that person. It's a positive connotation. What you know, and this is what Mr. Neufeld's point was, since the 70s, we now know that it was the second part, or from another individual whose hairs exhibit the same physical characteristics, that wasn't going into your reports. And that's what I don't get. I have no problem with you scientists having a debate over qualifiers, disqualifiers, disclaimers, qualifying statements. But you can't issue a report that ends up in a court of law that leads juror number 7 to believe that there was a positive association, which you call a qualifier, could. I don't call that a qualifier. Because when the DA gets up to argue his case, the DA says there was a match. They said could. Whereas you know, as scientists, that the science here says it could be a positive association, or it could be from somebody else with similar characteristics. That's what I don't get. And here's, just so I'm fair to you, not only did you do it with that, with the hair, where you take the positive connotation, but in car number 23, which dealt with glass, right? You did the same thing there. The connotation was that it could have come from the glass, the question to the known, but left out the second part. And now you agree, as part of the corrective action, that you're not going to do that anymore, right?
That's correct.
Right? And in car number 25, which is paint, right, you did the same thing. The paint could, the Q paint, the question paint, could have come from the known. But we now know, based on the corrective action, you're not going to say that anymore. You're going to say that it could have or it could not have. Am I correct so far? So here's my question to you. One of the things that that Barry Scheck and Peter Neufeld and the NAS Commission are very concerned about, we're very concerned about, is this business of making what statements, improper reporting, in the way it's conveyed to lay jurors. And it seems to me that given the option in hair, in paint, in glass, the option this lab always took, and this is what I'm after, is to say, yes, there's a positive association, leaving out the second part. Or it could have come from something similar. What I don't get is why you do that. You know that this is going to be presented to juries. You know that a defendant's life may hang on the line, just not on all the other evidence, because there might be cross-examination, directs, a lot of confusion. But the one thing we can count on at the end of the case is somebody from the lab comes in, the DA presents that, and we get this positive association. So here's my question. And it's what I asked you last time, Mr. Jenna, and I asked Mr. Doler and yourself. Is there a problem in this lab, in its culture, that has led it, in these three different areas, glass, hair, and paint, to always choose the option that is most damaging to the defendant?
No, there isn't. There never has been. It's always been our objective to submit the report with the wording that we thought was appropriate. And by stating could have was our way of qualifying that it was not a positive association, that it was a possibility, that it could have. We never indicated or implied, either in the reports or in testimony, that it was a positive association or a positive match. And that never was our intent. Now, as a result of this inspection, we reviewed all of the documentation. We even went back and reviewed the proceedings that occurred in 1985 to see whether or not there was any indication in there as to specifically what a qualifying statement was or if there were any disclaimers. And there weren't any specifically indicating what a qualifying statement was. It was only to substantiate your finding. In other words, if you made a could have possible association, you would qualify that with further characteristics such as the hair was dyed or had insect activity. And that's what they referred to as qualifying statements. And we did that on occasions, but predominantly we stuck with the could have wording in our reports, not to mislead. And even in testimony, you can check all of the deposition transcripts and testimony transcripts, and not once when an examiner was asked if there was a positive association did they indicate that there was.
In fact, it's actually our position that the could have statement is the simplest statement, easiest for a lay juror to understand, rather than putting in all these other things about positive identifications and DNA this and all these other statements. It was the simplest way to convey that this vehicle, this window, this individual and their hairs are a possible source. It's like could have.
Regardless of that, we now...
It's not regardless, Marvin. It is what we've been doing.
But now we can agree you've changed. We can agree you've changed. Now, here's my question.
Just as many other laboratories throughout the United States and in New York State have also changed as a result of the NAS report, the IG's report, and through their own ISO inspections have altered their reports so that it's consistent with the activities requested.
Well, let me ask
Hey, and Marvin and Barry, I just want to point out that the lab is changing their policy based on ASCLD Lab's recommendations. Just something to keep in the back of your mind when we're kicking ASCLD Lab.
Right. Well, first of all, that was
just when they were winding up, right?
and believe me, you can't sleep flat lab because they'd have to be up to do that. Let me ask you this question. In your materials, particularly Card 24, you point out that the ASCLD Lab program has a criteria 1.4.2.20, where associations are made is the significance of the association communicated clearly and properly. You follow that by referring to the international standard, the new one, the one that you're going to be under if you're approved. And that standard is 5.10.3.5. And you say, under that standard, the reports we've been issuing since 1992 and the numerous inspections, there's no difference between the old standard and the new standard, that you've been doing this since 1992, and no one ever questioned it. So is it your position that the legacy program standard, the international program standard, as far as you were concerned, and as you prepared for this, there was no difference. That's why you submitted what you did and said could have, and you felt that was sufficient. I just want to be clear in my own mind.
The criteria was essentially the same for the legacy as it is for ISO.
Okay, that answers my question.
I'm confused, okay? I'm looking at your, and maybe this is Brian's, I don't know, who did this survey that we got? The New York State Commission on Forensic Science 2013 Hair Comparison Survey.
It was done out of our office, Barry.
Yeah, I assembled the document, and it was sent to the labs for completion.
Okay, now here's what I don't understand, because if I got you guys correctly now, you've changed your policy, and now instead of just saying could have come from the source, you're going further based on what the FBI, initially said all the way back.
The FBI initially did not say that.
All right, we think
let's make that clear.
We think they did.
Mr. Schechner and Mr. Neufeld at the last meeting both said that there were qualifying statements in there, and they indicated that we weren't using those qualifying statements. And if you read the international report, you'll see that when they mention qualifying statements, it's to bolster the findings, whether it's positive or negative. For instance, if you had a positive finding and indicated that the hair could have come from, and you had other activities such as insect activity or dyeing, those are qualifying statements that they refer to in the international symposium.
Well, let's just talk about disclaimers, right? That
could I just ask which document you're referring to that you're reading from?
well, the one that Mr. Neufeld submitted to the commission, and I'm sure you saw, which is
that's not the international symposium.
No. But wait a second. This is Carrie T. Owen, the unit chief of trace evidence of the FBI. What Mr. Neufeld submitted, and he did a survey. He did a history of what the Bureau was teaching and what it was talking about with respect to disclaimers. And let's just get very, very specific.
What page are you looking at?
Well, there are a few of them here. Let me just cut to the chase. If I understand it now, you're telling us that you are moving forward, giving the disclaimer that in addition to saying that the hair or the glass or whatever other trace elements could have come from the source, you're now indicating that this is not a form of unique identification, right?
With respect to the hairs, that's correct.
With respect to the hairs, all right. We'll get to eventually, you'll see, the other ones will be in the same category. But with respect to the hairs, and wouldn't you agree that the FBI has always taken the position with respect to hairs that you couldn't say it was a unique identifier, right?
We'll agree with that.
All right, and there was a disclaimer. So,
well, I don't know if we don't agree with that.
I know you don't agree with that. That's what I don't understand.
You said there was a disclaimer. Where is the disclaimer?
Right.
Show me that.
All right. Well, we can get to what the FBI did or didn't do because
but
they were.
No,
wait a second.
If we're going to imply that there's a disclaimer, as we did at the last meeting, that there was a qualifying, and it's not there, then I need to know where the disclaimer is.
We can go. I don't know if it's going to be helpful, but Mr. Neufeld said to the document, the FBI itself said that they were telling people to issue the disclaimer, whether all the FBI agents did or not.
We looked through all of this documentation, and we looked at the proceedings in 1985, and they've never indicated specifically that there's a disclaimer.
Here's my problem about the disclaimer and about this survey. If I'm looking at page 1 of the survey, and this is what Peter put in his memo to you guys, there are 4 questions that were put in this, right? Okay? And, did you perform hair comparison? What years? Number 3, did your laboratory use a disclaimer qualifying statement for positive hair associations? And when we say disclaimer, we're all clear here. Not qualifying statement, disclaimer, meaning you're disclaiming that this is unique association, right?
The question is that this says disclaimer, it says both.
Disclaimer / qualifying
we
statement.
We have the survey right here.
It doesn't just say disclaimer.
Yeah.
It says disclaimer
qualifying.
So you mean for that section, you use the qualifying statement. And you're, just so clear, the qualifying statement for you is the word could.
Correct.
Right, so
Could
in
have.
other words,
Yes.
you're not telling us, because this is where this whole thing was undertaken in the first place. So, Brian, Brian, why don't you pay some attention? I see you off.
I'm diligently.
this is-
I'm enjoying it. Please proceed.
I don't understand, Brian. Look, in this survey that you gave us, they're saying, into the last question, please indicate when your laboratory began using disclaimer qualifying statement. And they have always used here in Suffolk County. And they're saying always, right?
Correct.
But you don't mean that you always used the disclaimer.
That
What you're
wasn't the
telling
question.
us,
Hold on a
no.
second.
The way you interpreted this question, hold on, if I got this right, the way you interpreted this question is either a qualifying statement or a disclaimer.
Correct.
And I thought the whole point of this survey was to see who was using the disclaimer and who wasn't.
Well, now, okay, you first started your sentence by saying, if I'm right. You're not right. You're wrong. We never said we used a disclaimer.
We agree with you.
Well, but you're using the word disclaimer and qualifying statement interchangeably, and that's not the way we interpret it, nor is it the way the FBI interprets it, and nor is it the way that Mr. Schechter and Mr. Neufeld were referring to it in the previous meeting. We need to set up understanding and definition. Qualifying statements are here, disclaimers are here. Our laboratory has always used the phraseology could have, and we felt that that was appropriate as a qualifying statement.
Right, I understand.
We never
used
claimed
it. You never used the disclaimer.
to use
Your
a
people
disclaimer.
were never testifying.
No,
This doesn't
but
mean
as-
personal identification.
That's correct.
You were never
Whoa,
putting in
whoa,
the
whoa, wait a
reports.
second now. Are we talking about testimony?
Both testimony.
In
well, that's what we
testimony,
asked.
we have had analysts testify that hair comparisons are associative evidence and not a form of personal identification.
Right, but the manual, just so we're clear.
But you didn't do that in every case.
But you didn't do it in every case,
Right.
number one.
Testimony.
And testimony. And number two, the issue in card 24 is clear. It says.
It's not clear.
It says here, it is noted in the same manual that you have a statement, hair comparisons are not the basis for absolute personal ID. The reviewed reports do not contain this statement or another similar limitation statement to properly qualify and communicate that the hair could have originated from other sources. So you left that out.
Can I answer that question? That phrase that was taken out of there was in the same manual. It's in our hair procedure manual. It's for a person that is viewing and learning and following that manual for their procedure. It's not part of our report writing section. It's part of an introduction to remind the analyst that this is our position on hair examinations.
So the reports did say?
No, the introduction to our section on the manual has that as something that's an introduction. It's not part of our required report writing.
Right, but so you took the position that on the reports submitted to the court, right, to the DA, that eventually are introduced into evidence, your position's clear. Even though we left out hair comparisons are not the basis for absolute personal ID on the written report, the other qualifying statement was sufficient to alert the court, the defense attorney, and the prosecutor that A, it could be from the same person, and that single qualifier in the written report also would tell the court, the defense attorney, and the prosecutor that it also could have come from somebody else, even though you didn't say that.
Oh, that's what the statement says. If
Okay.
it could have come from that individual, that means it could also have come from another individual.
I got you. Let me go on to...
You just said something about the FBI. Let's just be clear on the record. I know you say you can't find it. In the memo that we sent to you from the unit chief of the FBI, Carrie T. Oien, right? He says, all right, in order to ensure that proper weight is put on the results and interpretation of microscopic hair comparison, FBI laboratory reports for the past 40 years have stated that hair comparisons are not a means of individualizations in reports of examination containing microscopic comparisons. In addition, FBI examiners are trained to include at a minimum the same information during their testimony on cases during a hair association.
So it's a
You
disclaimer.
disagree?
No,
That's a report that came out in 2009, not in 1985.
That's what you guys were relying on the forensic report that you sent us was a 1985.
No, that's the
what you were-
report that you brought up.
Right.
At the last meeting, correct.
What's the date
What
of this
we-
report?
1985.
Well, that's what I'm asking. This is a 1985 report.
That's right.
Mr. Neufeld indicated to you that in the 1980s, in fact, earlier than the 1980s, it was clear that you couldn't do this any longer with hair.
No,
That's not
it's
clarity
not
on that
clear.
one, Marvin.
If you read that document, that
Hold on.
document and that document are completely separate.
Hey,
That's
Marvin,
from
we need a point of clarity here. The Suffolk guys, just hold on one second. There's some issues that need clarification. I think the reason for this survey was that Commissioner Neufeld asserted that in 1984 there was a national hair standard that was out there that said you had to do this. Factually, that's incorrect. What happened is there was a symposium in '85, the symposium you have a copy of, that talked about qualifying statements, and as the Suffolk County gentlemen are representing, those qualifying statements could increase or decrease the association. There are a number of other reports that have come out since then. Allow me to finish, please. And the 2009 report that you're looking at is actually a summary article from the unit chief of the FBI, and he's saying their internal policy is to do this. Nowhere does it say that everyone has to do this. Currently today, April 10th, 2013, there is no national standard that requires any laboratory to put that disclaimer statement. That is a choice of a laboratory. They think it's a good idea. They've told people to adopt it. Some have, some haven't. That is a point of contention that you need to just get over. Those are the facts of the situation.
In addition to that, SWIGMAT, who we look to for our standardization, in 2005 came out with their report. We modified our statements to have a strong positive association, a normal positive association, a strong elimination, and a weak elimination based on the recommendations of SWIGMAT in 2005. We are still waiting for an entity such as SWIGMAT to tell us that we needed a disclaimer in our reports. But we don't have the ability to go to the FBI and look at their internal procedures to see that they've had disclaimers for the last 40 years.
Even with the fact that SWIGMAT tells you that in 2005 and TWIGMAT hasn't done anything, you've gone ahead and made the changes anyway.
And let me say something further. Yes, we have.
Why?
Why? Because we think it's appropriate at this point in time.
Even though you haven't heard from TWIGMAT?
No, that's got nothing to do with
But
it,
you
Marvin.
put that into your additional remarks.
Let me preface what I'm going to say by saying that in the past, we never felt that we were putting reports out inappropriately in this field.
Right.
We were never doing it to be devious or to do something and imply that a defendant was or wasn't guilty or innocent. Since that time, and since the time of the NAS report, since the time of our inspection, and since the time of our discussions with the commission, we now feel it's appropriate to change our reports. And we now feel, from this day forward, that it's appropriate to put a qualifying statement in and to put disclaimers in the reports that we're going to be issuing. That's the point.
Right.
What happened in 1985, 1995, and 2005, we could sit here until 10 o'clock at night. And believe me, we feel comfortable with doing that. But this is what's going on right now.
Let me just ask you this.
No, wait a minute. I want to set some, Marvin, hang on a minute. We're not going to be here till 10 o'clock at night on this point. I think we've pretty much beat to death the specific issue of Suffolk and what goes in the reports now, what doesn't. If you have one or two more questions, but we're not going to spend more than another minute or two with regard to Suffolk. We've got to deal with this issue generally. So if you got one or two more questions, but wrap it up.
There are 25 CARs, Mike. It's impossible.
If you want to ask about those, but you've just been going back and forth about the same material for 10 minutes now.
I'll go on to something else.
If I could just clarify why we changed.
I wish we could, but the commissioner is trying to limit the discussion, so let's go on to something else. Same lab, R22. This has to do with the Biological Services Division. Is somebody hear from that? Mr. Galdi?
Wait a minute. No, Marvin, we're specifically on the hair comparison survey talking about the hair issue.
I'll wait till we get to the rest of something.
Okay.
I would just, as a last comment, I mean, I realize that this may be mind-numbing, and at least now we have some clarification of the facts. The survey, Brian, I don't think is, if it was designed to try to answer the question, how many laboratories put in a disclaimer when either in their reports or when they were testifying that hair comparisons could not be a unique personal identification. If that was supposed to be the point of the hair survey, as these gentlemen have indicated, that's certainly not how the question was interpreted. Okay,
And I think
that's why we were so disturbed by these results. The reason why that matters is that there's going to be a national reinvestigation of hair cases across the country, and we're going to have to probably do it in New York for every case where the hair examiners did not give a disclaimer, and there should be mitochondrial DNA tests done in these cases. That, if it's going to happen nationwide, right, in instances where the FBI agents certainly at the very least did not properly testify as to the limits of science, regardless of whether you think they adequately made that clear or it was just part of their own internal regulations. If they're doing it, then we're going to have to do it in New York. End of story.
The 10-year hair case summary that you guys did, that's what we're talking about here, how many, which is on page 3 of that card, 24, what was the result of the number of positive associations that you sent out in lab reports using what you called the qualifying statement could without the other statements? How many cases did you find?
We found 21.
I said to you.
And of those 21, have you spoken to the district attorney's office about what happened to those 21 cases?
Well, I think that needs clarification, because when we say that there's a positive association, that includes a positive association to what we call the host. So, for instance, if your shirt were tape lifted, you were the victim of a crime.
Right.
We collect hairs. We compare them back to your known head hairs. 19 of those 21 cases, that's the positive association we're talking about. What we call non-probing, the hairs from your shirt associated to you. Correct.
What about the cases where you compared the hairs and they were not from me?
Two.
We have. So those 2 cases, that's the number.
Correct.
In the 10 years. Those 2 cases, did you speak with the district attorney's office?
It would depend on the activity of the case. I mean, if the case, the report was either submitted to the police department and or the district attorney's office, or just the police department, and then if there was activity on the case, then the district attorney's office would have consulted us.
Do you mean to go back now and explain to them that there was no disclaimer? We still feel...
that you put in this qualifying statement, that you now made this change. There's been changes in the way the world... Disclaimer, whatever it is.
Ask your question. You're changing your whole concept now.
No.
Your question was, did we go to the district attorney?
Now.
And I said to you, that if there was an inquiry as far as an active case, then we would have gone to that. Otherwise, we would not have arbitrarily gone to the district attorney on these 2 cases.
But here's what
But the reason that we're adding a disclaimer, first of all, we are not required to add a disclaimer for our ASCLD accreditation. That is not what they're asking us to do. Their finding was that our qualification statement could have, in their mind, was not strong enough.
Right.
So we added the or another individual with the same. That was sufficient to fulfill that requirement. We could have stopped there.
Let me just ask you, on the 2 cases where you made a positive association, and it wasn't from the victim.
Well, it is actually from the victim. In both of those cases, one is on a weapon that was used, and there was a hair consistent with the victim.
Right. And the other one?
And the other case was a hit-and-run case where a hair found on the vehicle in question was similar to the victim in that case. We have not put out any reports where there was an association of a suspect to a questioned hair.
On that one case, just that one in 10 years, have you spoken to the district attorney?
There is no one case. We have not had any cases where we have made that type of an association through microscopic hair analysis.
Between the hair on the car and the hair on the victim.
Oh, I'm sorry, I misunderstood. I thought you were talking about the suspect.
In a hit-and-run case,
if
the hair on the car...
It's my car.
Okay, I misunderstood the question.
Okay,
we understand.
So in that case, let's assume it went to court. And
what do you mean assume? We don't know if it did or not.
Well,
we'd have to inquire.
Have you made that inquiry?
For what purpose? Are you asking us to?
What if somebody's in jail now, serving 20 years, based upon a trial that took place with your reported evidence.
All
that
due
the hair
respect, it's a hit and run. I don't think you're going to do 20 years on a hit and run. If you want us to inquire on that, we will.
Yes.
At this point,
Yes.
we don't know. We'll
All right,
inquire
I think
and
we're
we'll
going to
have-
end it right there. You've indicated you'd inquire. They'd like you to inquire, so please do with regard to that one case. Do we have anything else on this issue?
I think the issue very simply is there any wrongful conviction in the state of New York that we can identify where someone was convicted based on my cousin Vinny match of hairs? I can speak for Onondaga County, and I can tell you, no, we don't use. I've used hair comparisons once in 35 years, but I, on behalf of the State DA's Association, will certainly be willing to send a letter to all my 61 colleagues and ask them to go back and review and see if such thing happened. I would suggest maybe that Marvin and Barry could do the same for the various bar associations throughout the state of New York and make people aware of this. And is there anything about what Suffolk County is doing now that anybody objects to?
Not if they're going to follow through with all the cars.
We already have.
Okay.
And we already got a call from Asclad Lab that we passed the inspection.
But you've passed all their other inspections, as you pointed out, using the other qualifiers.
These are the rules on the field right now.
No, we've been through this. We're not going through it again. We're not going back through the whole thing over again. They've indicated that
We
they're
can
now
actually
complying.
answer the question, the inquiry about those two cases. We have a document that we prepared that indicates on both of those cases there was blood evidence with DNA STR analysis done that also came back with results on those, both the object in the one case and the vehicle in the second case, implicating the suspect or the suspect vehicle in that case.
So the hair played no role?
Well, it played a role. We had a result. We gave a report. But in addition to that report, there was a DNA STR analysis on blood also found on that vehicle that comes back. That correct.
Okay, so that case, where that evidence was found, those two pieces of evidence, was it a plea, guilty, a trial? Do you know?
We're going to find out for you.
I'd like you to find out.
We will.
I
think it was. There was no court testimony on that case, so we
We'll
don't know if
find
it
out.
pled or not.
Let's find out. Because you don't want to be sitting here, some guy's in jail, he pled guilty to 10 years or something.
They've already indicated 5 minutes ago that they're going to notify the DA, so we're beyond that. We've got to move on here. So that's enough on Suffolk. Aside from Suffolk, is there any other comment or statement with regard to the hair comparison?
Is that just on the hair?
I said on Suffolk, with regard to Suffolk, we're done questioning with regard to hair, yes. Just with hair. They're on the docket again in a few minutes. Is there any other comment with regard to the hair comparison survey?
Should be the back.
There's my prior life coming out. All right, if there's nothing else with regard to the hair comparison survey or that issue, then we'll move on. What I would suggest, if people don't object, we have people here from a number of laboratories across the state, and I would hate not to get to their issues. So if people don't object, I'll move to the agenda items that deal with laboratories where we have people here, just so they don't sit here and we don't reach their issues. Is everyone okay with that?
Yes, good idea.
All right. So you want to start with the laboratory disclosures then, number 8?
Sure.
All right. The first one is the state police. You want to take us through these?
Sure. What happened is we have a number of laboratory disclosures, and regarding the corrective action that's already been reported, we have Captain Monroe, Dr. Dusman, well, actually we had Captain Monroe, but we do, just responding to a corrective action regarding a missed sperm ID, and they were just giving an update on one that they'd already had.
Good afternoon.
Good afternoon. Barry Dusman, New York State Police. Because of the late hour, I've prepared a little summary, so I'm going to refer to that. This should only take 2 or 3 minutes. This is material that's already been reported to the subcommittee, and I'm going to intrude because Major Fun won't let me close it unless I run it by the commission. So we had reported earlier that we were beginning an extensive cause analysis based on a negative sperm identification by one of our analysts. And we presented to the commission last fall a 4-phase program to do that. The first phase was to actually look at the analyst, all the work that analyst had done in the past. That resulted in a negative sperm identification, and we completed that. We had completed that at the time of the presentation. The second was to look at everybody who had trained with that analyst to see if there was an issue with the training of our folks. And there were 2 people that trained with her, and there were 7 negative slides associated with their casework subsequently. We looked at all those slides. They were all negative. There were no sperm on them. The third thing we wanted to do is look at people, our staff, that don't do a lot of rape kits, and there were 9 of those. So we looked at the work that they had done, and that required, I believe it was 13 different, I'm sorry, I have to check that quickly. Just to get the number right. Do you remember exactly what that was, Julie?
We assigned 9 sex offense kits, and there was a total of 32 slides.
Yeah, 32 smear slides. They all came back negative. So what's new, and the update for this particular meeting, is we also said we were going to look at the work of all of our analysts to see if we had a systemic issue, one that wasn't related to training or to our protocol, but whether we had some sort of systemic issue. And we have looked at 35 of our employees. We've looked at everybody except 4, and those 4 actually didn't have anything relevant that they had done in the past. We had called on 113 kits to get the 113 back. From those, we were successful. We got back 54. We tested all 54, a total of 222 slides, and there were no sperm, all negative. So in total, we've looked at 267 negative slides. So what we're proposing or planning is that we'd like to close this cause analysis. It seems to be analyst-based, clearly analyst-based. She seems to have a problem with motion sickness when using the microscope. So we've removed her from this type of work and re-signed her.
Any questions or comments?
Thank you.
All right, thank you.
Next lab disclosure is the Monroe County Crime Laboratory. John Clark is the lab director and is here to represent that laboratory. There was a problem with the DNA analyst, and I think we can go into some detail on that. It's been previously reported, and now, as they're closing the corrective action out, some other additional information came out.
Yes, thank you. Good afternoon. As you said, there was an error by a DNA analyst during casework where they processed reagent blanks out of order. Because of that inconsistency or error, that person was placed under supervised casework. During that process or during that casework, another error did occur, which was cause for concern. That analyst was then removed from DNA casework, and we began a reanalysis of the DNA cases that analyst had worked on. There was a error discovered during that reanalysis of that casework where an error occurred during the pipetting of a 3130 plate setup. You should know that none of those cases that were reanalyzed had been reported out yet. So there was no incorrect laboratory reports were issued. The person has been removed from DNA casework and has been assigned to other duties. And we're just finishing up the completion of the technical and administrative review of those reanalysis reports.
Do you anticipate they'll go back to DNA casework?
We are going to keep her doing her current duties, which is not DNA casework. And after maybe a year or so, we'll revisit possibly retraining this person in DNA casework.
What about prior cases of this analyst?
All of the prior cases have been reanalyzed, and the results were found to be the same.
Well, what do you mean by reanalyzed? I don't understand that.
They re-examined and reanalyzed the evidence.
In other words, the evidence was then was cut again and extracted and because the error here appears to be sample switching, right?
Yes. So not all the cases were reanalyzed or reexamined. Some of them were reviewed. The data was reviewed to ensure that the results were correct.
Well, wait. How can you look at results on paper and decide that that it was correct when the underlying issue is you have an analyst that has been found to have done sample switching?
Forgive me, I misspoke. All the cases that she worked on were reanalyzed. There are cases which she assisted in where that data was looked at on those plate setups.
When you say, just so we're all clear and there's no misunderstanding, when you say all of the cases that she worked on were reanalyzed, what do you mean by reanalyzed?
I believe that all the evidence was reanalyzed or reprocessed in the cases in which that evidence was available. I'm not sure if it was every item. I would have to go back and check the details in each of those case reports.
Do you know roughly how many cases there was?
I believe it was 28 cases.
And over what period of time, just again, roughly?
The period of May 11th through October 11th. I'm sorry. The errors, forgive me. Yes. From May 11th through October of 2011.
So you're saying this analyst only did work on any cases between May and October of 2011?
Yes.
That's all the work she ever did on DNA cases in the laboratory?
Yes, she was a fairly new DNA analyst.
Okay. And so there were 28 cases, and you went back, and somebody went back and systematically looked at evidence items, resampled them, and conducted new analysis. Is that what you're telling us?
Yes.
Okay, and was the district attorney and/or if anybody was ever, you know, if anybody was arrested in any of these 28 cases?
No, I don't, but the cases in which the errors were discovered, there was one other case, those results were never reported out. So it was caught before the report was issued.
Right, that I understand. But in the 28 other cases that she worked, it's a she, I'm sorry, the analyst was a she, or a he, I didn't catch that.
They, it's not important.
Okay, well, the analyst. In the 28 other cases, if what I would suggest is that you determine whether A, they were reported out, and B, notify the policing agencies and the district attorneys that these cases were done by an analyst that had an error that was sample switching, that was sufficiently serious that you removed her, and notify them that the case has had reanalysis done. And appropriate notifications, I would hope, would be made. I would hope direct notification would be made to any defense bar representatives in Monroe County about these specific cases, so everybody knows that this happened. Is there any problem with that?
I'm not sure. I'm not clear on what you're requesting.
Let me ask you a question, if I could. you said that in the cases where there was sample switching, no report had been issued yet. Is that correct?
That is correct.
All right. And in the 28 other cases, you did reanalysis?
Yes.
All right. Would there be another report issued indicating there was a reanalysis and indicating the results of that reanalysis?
Yes, by the second analyst.
Were those reports supplied to the DA's office, the submitting police department, whoever submitted the evidence, the reanalysis reports?
Yes, they would be sent to the agency that submitted the evidence and the appropriate district attorney's office.
So in essence, then, you have notified either the submitting police department and or the DA's office of the reanalysis on the 28 other cases?
Well, as of this date, not all of those reports have gone out yet because they're still in the administrative review process.
But it's your intention when that process is completed to send all of those out?
Yes.
But in these reports that you're giving, are you indicating that the reason for the reanalysis is that the first analyst was somebody that had previously been found to have switched samples?
No.
Well, Mike, with all respect, that's the point. I mean, it's good that this is a new analyst, but to the extent that there have been any cases where her work has proceeded to arrest or indictment or a criminal investigation is pursuing, it's just what we ought to have, I thought, we'd all agreed, is that there ought to be notification to the a defense representative as well as to the proper prosecuting authority and policing agencies that there was a problem with this analyst on these cases. So people have notice of what the issue is.
I don't recall us ever agreeing that there should be notice directly from the lab to the defense. I do recall discussions regarding notice to prosecutors, and the fact that prosecutors then have a legal obligation to act on that.
Well, I think as a result of what happened in the Nassau situation and our subsequent discussions, I think that there was some understanding among the commissioners that we were going to try to put in place a practice whereby appropriate defense representatives, if not the lawyers actually representing the individuals, would get notice, or certainly somebody who had could be a contact person for the defense community would get notice as well when you have a deficiency that is of this serious nature. And the reason I say it's a serious nature, I'm sure everybody appreciates. The problem with sample switching is that, it's just a very hard thing to protect in any subsequent cases, which is why you reanalyzed everything. I just think it ought to be clear, and it's not that many cases, it appears, that this is what actually happened. So
Let
this
me
transparency.
Starting with the DA, do you have any objection to notifying the prosecutor? If they all came from one county, notifying that prosecutor. If they came from different counties, notifying the prosecutors in the counties that they came from of the issue?
Can I
Yeah.
say? My understanding is that the obligation is if a lab has an issue where an analyst has a significant mistake, and we perform a corrective action and find cases where that's been affected, we notify on those cases. Not that we would notify on any case that person's ever worked.
So we have five cases here that fit into...
My understanding is the 5 cases that you found a mistake in, you would notify on those cases. Not, if that analyst had been there for 10 years and worked 1,000 cases, you wouldn't tell the defense attorneys in 1,000 cases that on this day she had a mistake in this other case.
Well, no, but I think that we're talking about a rule of reason. What we're trying to do is develop procedures here where, you know, if it were 10,000 cases and we had somebody that had done sample handling error, we've already had, we all know, cases where we've had to review hundreds and hundreds, right, of analysts. But you would want to do some random review, right? You would want to do some, you know, sense of the problem. But this is not, you know, some simple transcription. This is a sample switching thing. And then when they looked at her again under supervision, there was an additional mistake. So obviously she was pulled off cases. That's not trivial. That's something that, you know, I think that the people, if a criminal prosecution is to proceed, it's the kind of thing that I'm sure the district attorneys in the county, the judges, and the defense bar would want to know that this was one of the just 28 cases worked by this analyst about whose competency there was sufficient concern that she's no longer doing this work, because these were not small errors. And when she continued to work under supervision, there was another problem. I mean, that just calls everybody's attention to it, so we can all be clear that people know what happened.
I don't think
it's a whole lesson to pass off.
I don't think it should matter the number of cases, because you can't make a rule if it's 25 cases, we're going to let them know, and if it's more, we're not. I mean, you're out.
No. It has to do with the seriousness of it.
I understand that, but my understanding is the obligation is to notify if you have a case that has an error in it. Not if you were to review 200 other cases and not find any errors. I don't know why you'd have to notify every one of those prosecutors and defense attorneys that we looked at it and didn't find any errors. It doesn't make sense to me.
I'm not, when you're talking about lab notification, lab is notified the accrediting agencies of this serious error. They have notified us of as a commission of the corrective action. It was sufficiently serious that even when she was being supervised, there was another problem. They decided to pull her off casework. Okay, I have all this right. It's just 28 cases. There are no specific rules in place yet, although we voted to consider adopting them. We had the voluntary system that the district attorneys would want to notify, would want to be notified and would make notifications when there were errors or corrective actions. My modest suggestion to Monroe, and nobody's saying that they have to do this, but I think we should do it as a commission, is that you ought to notify the district attorneys in the affected counties about these particular cases, about the problems you had with this analyst, and in turn you ought to notify either the head of the defender's office, if there is any in those particular jurisdictions, or the appropriate state bar defense representative. That's all. And people will then know.
But the lab has gone to all the work to pull all the cases and verify that there's no error in those other cases. Why do they need to tell anybody they did that? You just want them to tell people that the person who worked on the case who didn't make a mistake on their case has made mistakes in the past? I mean, what are they telling them? That the technician who worked on the case at one time made 3 mistakes, but not on your case?
Well, it's much more than that, Ann. I mean, that somebody did something as, well, what happened? There was a sample switch, which is about as serious as
not
you get.
Not on the case. Not on the case in question.
There was a sample switch in a case. And then when she was supervised, there were still errors, and they decided to take her off casework.
Yeah, but that's not
relevant. That analyst?
That's not relevant to the particular case in question, because they verified that the results are accurate. I don't think we should be punishing lab techs for the rest of their lives because they made a mistake, even 2 mistakes. I don't know why anybody would go to work in a forensics lab if you're going to disclose publicly every time somebody dropped a reagent bottle or had to pick up a pipette or had to redo a test. I think you want corrective actions to be constructive, not punitive. We're going to disagree on this one, Gary.
That's not what happened here.
On a different issue, John. I'm sorry, I just have a different question. Have you got to the root cause of why this person is making these mistakes? Is it inattentiveness in this person's actions? And if it is that even possible that you can retrain them?
We haven't. Obviously, when you go through these corrective actions, you never truly find out why these mistakes were made. It could be any number of things, and you don't want to eliminate any one of those. So hopefully, with some more retraining and more thorough retraining, that, if we decide to put this person through a retraining, they can become a good analyst.
I guess what I'm getting at is also just because, there's a significant firearms backlog in Monroe County, maybe this person in their interim can actually be doing conferrals to try and reduce that backlog, to try and prioritize the evidence appropriately, find cases that are already done and don't need to be done, or where there's no value to, and separate those from ones that are happening, to try and, instead of just keeping them on purely administrative duties, to still help with the overall lab's mission.
Well, they are serving that purpose, but in the forensic biology section of the laboratory, doing conferrals, following up on cases, conducting communications with our submitting agencies.
I'd like to go back to the air. I don't know the 3130. Is it designed to minimize risk for these transposition of samples?
It was a
risk for others to do the same?
It was a matter of not verifying the labeling during the pipetting. So when we looked at that, we did go back and look at any of the setups that this person assisted in, or in other words, helped the other analysts with. So not just her cases were looked at, other analyst cases, and those 3130 setups were also looked at.
What's the question of system failure versus, personnel failure? If the analytic system is designed in such a way that the risks are high for these transpositions, you need to look at the analytical system. Ideally, barcode should drive identification and not rely upon, the analyst, verifying that this label matches this.
That was part of our corrective action as well. There is a device that provides light for the appropriate well to be, for the sample to be pipetted in. We looked at that and actually purchased one of those devices.
Any other questions for Mr. Clark?
Not a question, but I guess I would say that at a minimum, I think as Kathy indicated, on those 5 cases where there was an issue, the prosecutor ought to be notified.
But on those cases, he said the reports weren't even written, so they hadn't gone out yet. So I think on that, in a normal instance, yes.
All right.
If the reports had already gone out, you would notify the DA, absolutely.
All right.
But and just so we're clear, it wasn't. The other errors were minor, such as not adding all components to an amplification reaction. They weren't sample switches as well.
There was one
instance
where the sample was switched.
And that, again, that was caught before the report was ever issued.
Okay.
All right. Thank you, Mr. Clark. The next laboratory, Suffolk County Crime Laboratory, there's 2 new corrective actions. One is a weight discrepancy on a drug case, and the other has to do with transposition of a victim and suspect's name on a report. So, all right, so Mr. Jenna, is there, just to follow up on those 2, probably more on the first than the second. The second seems relatively minor.
Yes. What's your question, Brian?
Just following up on the weight discrepancy on the drug case, if it's possible, just give kind of a quick summary of what happened with that and what the progress is.
Okay.
It was an analyst was weighing there was 4 different bags that were submitted for analysis. One with a heavy weight, and the other 3 had similar smaller weights. The analyst weighed the first larger weight bag twice, so therefore had ultimately had the report issued. The report that was issued had a higher charge than expected. to look into this, we looked at cases that this particular analyst was analyzing around the same time. We took cases before this particular date and after this date. Had other analysts within the section weighed them. There was no other inconsistencies to those weights. The analyst was removed from casework when we saw that the first issue of the misidentification of the weights. She's currently in a supervised casework right now.
So it's your feeling at this point this was kind of a one-off?
Correct. There's no other indications that it's any other analysts are affected by this. We've pulled 15 cases during that same time period. There's no during the reweighing of those cases, there was no significant discrepancies in the weights, as well as a few of the cases around that same time period were completely reanalyzed by another analyst. The particular case in question was given to another analyst who reweighted it, as well as a full reanalysis was done on the case.
All right, and an amended report was issued, and the DA was notified, correct?
Correct. An amended report was issued, and we've had meetings with the DA's office concerning it.
Any other questions about these two discrepancies? Thank you, Suffolk County. Next lab is Onondaga County Center for Forensic Sciences, and there is a previously reported car and a new car. The previously reported car had to do with the loss of a trace evidence collection, and the new car we kind of discussed already regarding the firearms, so I'm not sure if we want to go into that again or not. So Dr. Corrado, if you want to address any of those.
I'm happy to discuss it or happy to take questions. If no one, for time's sake, if people don't have any questions, that's fine with me. If you want me to discuss them, I will.
Questions for Onondaga? Okay, thank you, Dr. Corrado. Erie County Department of Central Police Services. Dr. Simich is representing that laboratory here. He's the director. There is a discrepancy in the firearms unit. It's a little involved, so I'll have Dr. Simich explain it. It has to do with actually looking at the class characteristics of a recovered projectile. Dr. Simich?
Yes, this corrective action came about as a result of our reanalysis program. This examiner was chosen to have one of their cases reanalyzed. The case involved the determination of class characteristics of a fired bullet, and that we report as part of the workup, and it does go out in the report, the number of landing groove impressions, which can be used later on for investigative purposes. There's two ways of doing that. You can literally count all of the landing groove impressions around the entire bullet if they're all visible. Sometimes the bullets are damaged and portions of it are not visible, so you have to then calculate based on the width of the landing groove impressions. There are formulas and tables that are available to allow them to calculate it. The method that you have to use for that bullet has to be recorded in your notes, how you accomplish that number that gets reported. Okay. In this case, there were 3 bullets for this one investigation. The notes indicated that bullet number 1, they were counted, 16 landing groove impressions. Bullets number 2 and 3, they were calculated. During the reanalysis, the second analyst doing the reanalysis looked at bullet number 1 and saw that he could not count all 16 landing groove impressions, hence he alerted the supervisor. Bullets number 2 and 3 verified, yes, you had to calculate them, so they were correct. We had a second analyst then look at the bullet blindly, and he was asked, could he count the number of landing groove impressions? He agreed with the second analyst that he had to calculate them, and the supervisor verified it. So then at that point, we decided to re-examine all of this individual's cases that involved class characteristics of bullets and cartridge cases. There were 13 in total. Couple of other minor note errors were found, or note deficiencies. I'm not going to call them errors. They were deficiencies in the note-taking process. Let's see, one of them did affect the report. We had to send an amended report out. It was a terminology. Report said bullet. It should have said bullet jacket. The other ones did not result in the need for amended reports. One of the other ones, it was reported that the bullet had some individual characteristics for further evaluation. The notes did not state that. The correct answer is some individual characteristics, absolutely. So the notes were corrected in that one. So looking at all of these reports, we felt that the root cause really boiled down to inadvertent documentation. In other words, they weren't documenting everything correctly, or it was insufficient documentation during the note review process. The analyst is currently has been put back on that type of casework after being instructed in thorough note-taking. And the next 10 cases of this nature that they will be performing are being 100% reviewed by a second examiner to ensure that everything is proper and thorough. In addition, we've also developed forms for the firearm section. They're literally just developed, and they're going to be put into place possibly the end of this week or early next week for all of the examiners to begin using to more standardize the note-taking process and documentation. And that way things will not be overlooked in the future.
Questions for Dr. Simmons?
You also identified that technical review protocols need to be revised. I was somewhat surprised to read that the technical reviewer was, in fact, the analyst, if I read that letter correctly.
No, the technical reviewer was not the analyst. What happened on this case is the technical reviewer was the section supervisor who actually had taken it upon himself to do the bulk of the technical reviews in the section. And that, while we don't have a policy on that, at times you can become, I'm not going to say lax of a better word, I'm going to use the word lax, but you can not be as thorough as you probably should be. So we, in order to address that problem, we instituted the policy of spreading the technical reviews around to other analysts. And that will hopefully alleviate that. One person looking at case after case and sitting there doing reviews all day, you can become blinded sometimes. And we have found that years ago we had that happen in DNA back in the mid-90s. So that can absolutely happen in a laboratory.
Well, I mean, it suggests that whoever was doing the technical review wasn't competent to do that or attentive.
Well, here's the problem is that I will admit on only one that was true, and that was the one where she did not have some individual characteristics. That should have been in her notes. The technical review for this type of case in our laboratory is looking at the notes, not looking at the notes and looking at the evidence. That would be a verification. We do verifications only for positive component comparisons, either bullets or cartridge cases. And that, they literally look at the evidence and verify whether or not they agree with the notes being reviewed. All other types of technical reviews are done by looking at the notes. So there really is no way to catch that on a technical review, that she should have calculated it, and she couldn't have counted it, she should have calculated based on the description of what there was. So it really was the error was her note-taking was not thorough and not as accurate as it should have been on that. And a technical reviewer really can't catch that unless you look at the bullet directly. And we're not required to do that as part of the technical review. It's not required.
Is it a good practice to do so? I mean, what you're describing, I think, is administrative review. If you're looking at notes to make certain that they're complete.
Well, not really. That's the technical review. That's exactly what's done in DNA. It's done in chemistry.
Administrative review is looking specifically at non-case, like looking at the name of the person, the case number, things that aren't technical in nature. Technical review is looking at the notes to see if the notes support the conclusions in the report. But
how can you do that if you're not looking at the evidence?
Because you're looking at the notes. You're looking technically at the notes and say, do the notes that are documented of the evidence support the conclusion? And that's not unique to forensic science. That's technical reviews in many other industries. Do the notes support the conclusions that are in the report is the tech review. And the administrative review is, case number's correct, the analyst's name's correct, the date's correct, the precinct's correct, or the submitting agency's correct. They're distinctly different things because administrative review anyone can do. With technical review, you have to be a subject matter expert to understand the discipline to actually do that. Sorry to interrupt.
No, that's fine. But to answer your question, do I think it is? In an ideal world, absolutely. The staffing required for that would be phenomenal. It would be even more than doubling the staff that we have now. Actually, right now, we're down 3 people, so, in firearms. So we're hurting for another month and a half or so.
Other questions for Dr. Simich? All right, thank you, sir. Last one for the lab disclosures is the New York City Police Department. Chief Pulaski, Dr. O'Neill, essentially relating to the hair survey. So if you could.
Yes, I believe it's in the letter that we sent, if you have any questions for me. This is something that came up from us completing the hair survey.
Right, and essentially, just for summary, just to refresh this, we're many hours into the meeting and we still have many hours left to go. The lights might kick out at 6 o'clock and kick us off, so we'll see if that happens. It doesn't in this building for energy saving. But essentially, the sum and total is that some cases didn't have disclaimer statements in. The laboratory had corrected that problem and has ensured that that problem will not occur again through the LIMS system, the implementation of a LIMS system that actually automatically makes sure that's attached. So, questions for Chief Pulaski, Dr. O'Neill? Okay, gentlemen, thank you.
I think the next item we should take, since we have Suffolk here, the last item on the agenda under, I think it's old business, would be the Suffolk County Crime Laboratory. Brian, you want to?
So essentially what we have over here is there is a letter to DCGS dated February 27th recorded indicating that members of that laboratory will be at this meeting, and there's a update on all the cars that are coming through. So the members of the Suffolk lab, all the different sections are here. If there's questions about the specific things, I know Marvin, you've been chomping at the bits to get to it, so now's the time.
Great. Brian, I just want to inform the commission that we got notification this morning that Ascot Labs board met this morning and gave their approval. Just wanted to make sure the board, commission was aware of that.
Thank you, Dan.
Okay, so just to address Card 22, Mr. Galvin?
Yes.
My name is Mark Shepard.
How you doing?
I don't have a lot of questions about Card 22. They're more confirmatory than anything else, unintended. I just want to be sure I understand what you sent to us and the reasoning. With respect to the terms consistent with human saliva and blood, and with respect to the term chemical testing indicated the presence of blood in the leukomalachite green test, whatever you were doing before, you've now changed.
That's correct.
Is that correct?
Yes.
Okay. And in the materials that you sent us in Card 22, and this is what I really want to try and get from you, is that you felt, at least until this change, you were justified in using the terminologies that you did for amylase, hemotrace, and the leukomalachite test based upon the Asclad lab approval that you had gotten previously for this use, that the Asclad lab inspections in 2005, 2007, and 2010 did not result in any findings regarding the wording used for presumptive body fluid tests, including the hemotrace test, correct?
In addition, in the 2002 inspection, they sent us a memo specifically stating that the wording was appropriate.
Right, so all the way back from 2002 all the way through 2010, the direction that you got from the accrediting agency was this kind of reporting. Terms you were using was fine and correct with them.
Correct.
Okay. Now, the only last question I have on Card 22 is on the last page of Card 22, it's only 2 pages, the second page, you raised a section in which you quoted from the North Carolina SBI issues. You see that?
Yes.
And you quoted, there are 5 bullets, for want of a better description. Those 5 bullets, you put that in here to indicate to this commission that the problems that SBI had were similar to the ones you're having.
No. I put those in specifically to indicate that they were different from what we
So that's what I'm trying to figure out. The reason you put that in here is that you were different than SBI.
Absolutely.
Because SBI took a positive test, there was a confirmatory negative, and they reported it as positive.
Correct.
You put this section in here to show that's not what you.
That's correct.
Is that correct?
Yes.
All right. And
We would
last-
specify that either further confirmatory testing wasn't done or that confirmatory testing was negative.
And just to go back over what your contention is about from 2002 to 2010, when Asplat Lab approved of the use of your terms, such as consistent with human saliva and blood, and chemical testing indicated the presence of blood. Your belief was that wording was meant to convey that it was not confirmatory.
Correct.
Okay. The only question I have is, to the lay person, to a defense attorney, a judge, or a prosecutor, how would they determine from the use of such terms, the way you originally had it, and which were approved of by your accrediting agency, how would somebody determine that, looking at that statement on a lab report, that you were conveying that this is not confirmatory?
Basically because the statement consistent with is not stating that it is human blood. We were being very specific about that. We were not saying human blood was detected in this. We were just saying the results were consistent with human blood. And we were using a word consistent with as opposed to more scientific terminology that we felt would be more understandable to the layperson.
So in your opinion, consistent with is better language in the term consistent with is better language than what you're now going to switch to?
No, I didn't say that.
Is it better language consistent with than what you're now going to switch to?
I say it's equivalent. What's different about what we're doing now is that we're adding the statement that a presumptive test, or we could have said the phrase consistent with is not confirmed. That's basically the bottom line. We're defining whether it's consistent with, indicated, presumptive. We define what that means, and we're doing that now.
That's what you do now.
Correct.
But back then, in terms of just we're on the report as reported, consistent with indicates the presence.
That's correct.
One last question, just from me. Did you personally have a chance to read the NAS report?
Yes, I have.
Did you read this section? I think it's on page 183 on reporting.
I don't have the pages memorized, but I'm sure I did.
And there was a section where the NAS talked about the use of terms such as consistent with, match, identical to the exclusion of all other certainty. Did the NAS condemn the use of those terms as being inappropriate in forensic testing? Do you remember reading that at all?
I remember reading it. I don't recall them defining it as such, so I'd have to see it again.
Okay. Nothing further.
Okay. Thank you, gentlemen. There's no vote required on this. It's just purely an update. There is on the old business bill, there's something that's a letter comparison of ABFT and ASCLD Lab. There are some notes in your binders about that. Essentially, both NICLAC and the TOX-TWIG have deferred until the comparison of accreditation providers is performed by Dr. Jenny and myself. One quick note to that end, I'm asking for an extension of that. We were initially looking at the June 26th meeting for us to have that completed. Because of all the advisory councils and things that we've been doing up to now, I haven't made as much progress as I need to on this. So what we're going to do is Dr. Jenny and I will present our progress at the June 26th meeting, but what's going to end up happening is the final report will be in the fall meeting, whatever period that be. And it's just maybe a good segue for that. So if anyone has comments about that, they can, but really I would recommend there's no issue about it because they're going to talk about this stuff later.
All I want to say about the ABFT is I don't know if the new revised checklist, the draft was distributed to all the lab directors.
I received a copy.
You've received a copy, okay. And it should be implemented November 1.
Okay. And the next thing down with the Nassau County Department of Forensic Sciences latent print comparison. Now, Marvin, I know you had requested that, but unless there's significant concern, or maybe is that something we can put off the next meeting to get some of the other meat of the things we have to do today?
Well, what are the other things we're going to do today?
Yeah.
Well, the advisory councils, the certification, I'm hoping some significant things.
Well, I do need to leave in 5 minutes.
So maybe we can, we have 5 minutes of Dr. Jenny's time, so maybe could we move to I don't need to take your role.
Well, is there an issue with regard to the latent print comparison SOP? There was just a request that that be provided?
Yeah, I think that there are a number of questions about that. So we're trying to prioritize. I'm just trying to figure out.
All right.
Is there anyone from Nassau County there?
If people don't mind, let's put that over till the next meeting if there's questions. Dr. Jenny was involved with the advisory councils and with certification. Maybe we could deal with those two issues. You want to start with the advisory councils?
Yeah, if you don't mind, I think the one that Dr. Jenny proposed was the Quality Assurance Advisory Council, and I'd helped them kind of put that together. So one of the recommendations that happened from our last meeting on Nassau County was for Dr. Jenny and myself to come up with a structure to put out there of something that would be an advisory council to the commission, understanding that unlike the DNA subcommittee, their votes would nothing they did would be binding, but they have the advisory capacity. So a document was distributed to everybody to give an idea of that. It's a one-page document where not only did we outline what they would be doing, what we did is we discussed a membership of that organization and actually made specific membership recommendations with the idea that, potentially we could get this thing going. If there's buy-in to do it, we could get this thing going relatively quickly and have this freestanding advisory council to the commission that these issues regarding technical administrative review, internal audits, root cause assessment and nonconformity management, competence assessment, measurement uncertainty and reporting, and laboratory reanalysis programs could be addressed, that this group could actually make recommendations to the commission and the commission could give them questions that they could pose.
Well, I must say you gave us this last night.
Monday.
Is that right?
Monday.
Today's Wednesday. I really don't have any problems with the mission statement and the objectives because I think those are all relevant things. I think that there has to be a lot more discussion and consideration as to the member qualifications and as to the membership recommendations. We don't even have time to discuss, nor do I think it's appropriate, frankly, right now, but there are some significant problems with the people that you propose.
I'd like to hear them.
Well, before you hear them, I'm a little bit puzzled why it's appropriate in proposing an advisory council for the Office of Forensic Services to suggest two people when certainly the commission might have other contacts and other people who we prefer.
Well, wait a minute. In fairness here, at the last meeting, we asked every commissioner to submit proposals with regard to these advisory commissions, and we didn't get anything. So the only thing that's been put forward is what Brian, and to some extent, I think with the help of Dr. Jenny and maybe a couple of others, but everyone was asked, every commissioner was asked at the last meeting to put proposals forward, and we didn't get anything. So I don't think we should be criticizing the Office of Forensic Services because they chose to do something here.
No, if I could.
If we have comments about the people, that's fine. Let's entertain the comments. Let's talk about it. But let's not, keep it on a professional level here.
I think that the two individuals that you propose are really not. I think it represents a 10-year in terms of the discussions that have been going on in the last few years. I think it's well known that Peter Marone is a very controversial figure. He was on the NAS commission with Marvin and others, but almost immediately after the dissemination of that report, he literally seemed to renounce most of the key recommendations in that report, and has been a very controversial figure within what they call the CFSO and the American Academy of Forensic Science, and has repeatedly clashed with lots of people at congressional hearings on this subject. There's a lot of controversy with respect to how he ran the lab in Virginia, and I can't believe you don't know that, Brian.
Wait a minute. Come on, let's keep this professional, all right?
No, I don't mean to be
No,
unprofessional.
we don't need that type of editorialization. If you are suggesting that you have problems with people or that you want other people, that's fine. The reasons are fine, but no, don't attack Brian.
I'm not attacking.
Yeah, you
I
are.
think it's, all right, I am attacking. I know it's not an attack, it's a quibble. All that I'm saying is,
It's too late for quibbling.
well known. This is extremely well known about how controversial a figure he is, and I'm sure Brian knows that. If you want to interpret that as an attack, that's fine. But,
Just before you talk, I just wanted to address that quickly. Very quickly, though. First off, I don't think he's controversial, but even if I did, this commission is holding two lawyers on the other end of this teleconference that I think everyone would say are pretty controversial, and I think they're beneficial to this commission. So I've never heard the name Peter Marone in controversial lab.
No, but it's not. It's in all fairness, Peter Marone can be. I think he would probably even agree himself. Would be considered a representative of kind of old school forensic science. He would not regard him. I don't think he would be described by anybody as somebody that's in the forefront of reforming lab practices or doing root cause analysis or any of the measurement uncertainty reporting. He has been a critic of the report that he voted for. And he has been very controversial, I inform you, as an objective matter, for those reasons. And we all know Vince very well. He's a very nice guy. I've never doubted his integrity. But again, I don't think that when you're talking about the kinds of things that the National Commission is going to be looking into, that hopefully we would be looking into, what is root cause analysis, what kind of measurement uncertainty issues are going to be arising out of this National Commission and the guidance groups. I don't really think that he's somebody that is going to be value added on that score either. And certainly if you're going to have either of these two gentlemen as members, you should really be expanding the membership with some significant suggestions that we could make to you, and I think that we're doing that. So I'm troubled by the limited group that are stated in the membership qualifications, and certainly on these membership recommendations. And I'd be happy to provide some alternatives, but at this late hour, to begin to get into this discussion now, I think is not going to be productive.
Yep. I agree with you, Barry. If I could just comment briefly. The intent of this document is clearly identified as a draft proposal for an advisory board. The directive in last meeting was to develop a document with input from commission members. The purpose of this document is to promote that discussion. Between now and the next meeting, we have to work on some mechanism to get the input from commission members, be proactive. We attend a meeting, we have assignments, we walk away, and it's not until we return that these issues are brought up again. So between now and the next meeting, we have to arrive at some mechanism where we can have these discussions, Barry, to get input. I mean, we did as expected. There was a commission member that made recommendations. There were only recommendations for discussion by the commission at large. So please, between now and the next committee or commission meeting, let's all become engaged in reviewing these proposals and develop them to a point where, in fact, at the next meeting we have a product that we can actually take action on.
I guess just to follow up on that, Barry, I appreciate your offer, and I would just ask that if you do have names that you think would be helpful, that you get them to us ahead of time.
Yeah, no, we will do that. I mean, I don't think there are people of outstanding qualifications in the medical community and the people that I'll tell Dr. Jenny about that have agreed to put their names forward for the National Commission, right? That I think we can really advance the ball here, and we'd be more than happy to make additional suggestions about member qualifications and membership recommendations here. And I mean this is no disrespect and no kind of personal attack or anything. But we would have been more than happy to do that earlier, and we'll do that now, and we'll all move forward in a constructive way. But it would be a mistake if I didn't indicate to you that certainly. Well, let's just leave it at that.
If we could get the CVs for Mr. Crispino and Mr. Marone,
well, we know
that would be helpful.
We know them. We know them. We know them.
Want to make a motion on that? Right.
Okay. I would like to make a motion that, I mean, I know that a lot of work went into this. Can we make the motion to vote on the member qualifications? Because
No, I really object to that. This happened at the last minute. I think the membership qualifications, there are more people that should be put on this. I think that we have a chance to get people from, the major medical communities within the state of New York, major hospitals, major scientific people that would agree to be on this. That could really move
We're just talking qualifications now.
Hang on.
Yeah, so I'll second it.
You're saying not the specific people, just the structure that's
just the structure that's described here.
I'm objecting. I think that we can have more people as the advisory group than just somebody from the accreditation providers that we already have in New York. And I think we would like to expand this. We'll make some specific suggestions on how to expand it and make additional personal recommendations. So I don't think that, I think it would be unwise to start voting on that now.
But we do have a motion. We have a motion in front of us, and we have a second.
And this is just for the quals, not the people themselves. Right. Yeah. Okay.
This would be the mission, the objectives, and the member qualifications, correct?
Yes.
Well, if it helps, I have no objection to the mission or the mission statement or the objectives, but I think we should be expanding the group of people because I think it's too narrowly defined in terms of who would serve on that advisory board. That's all.
All right. Now we have a motion. We have a second.
Is the spirit of the motion to limit the membership to 4 or 6? Or whatever that, I can't count.
Because the second one is multiple people.
But, well, it's only 2.
It's all in good spirit, yeah.
External.
So right as written, it's 5 people.
If we retain more.
Right, so if there's FQS or other providers that come in.
Well, there could be other future providers, yes.
Right.
But
right now it would be
for
2.
the moment, it would be 5.
Yeah.
Was any analysis done, just to inform the process here, of the cost? I mean, some of these people are outside New York, and is DCJS, is there a budget for this organization? Is there a staff? Well, I mean, it's going to cost money to do it.
Yes.
Because I'm going to suggest one of the added, motion, this is not to change the motion for the structure, but a part of the evaluation needs to be the cost benefit. Is this really where you want to put your money, or is there another way to do what you want to accomplish? I'm just raising that as an observation.
Could have used your last meeting, Ann.
And I too, I'll be happy to provide some input. Apologize for not having done it. I would like to see the breadth of the not the number necessarily, but the breadth of who's on this group. Not going in the direction that Barry's going, but So I do think we need to give you some input, and I would be concerned about limiting it to this 5 people qualified by their current title or function.
I guess just throw this out there, there would be nothing to prevent us at a future meeting from amending it.
Well, then maybe we need to add another little box that says, and others as deemed necessary.
I don't want to do that.
No, I think the commission can act at any time, right, to change. Yeah, so we have a motion, we have a second. It gets either voted.
Personally, I do think it's premature to take that vote. This material was presented only 2 days ago. Commission members really haven't had an opportunity to review and provide the input that was expected in preparation of the more substantial document.
I guess there is a frustration on my part, though, in that the last meeting, we clearly asked people to submit information and proposals. We got nothing. Well, other than what Brian put together with your assistance.
Yeah.
I hate to suggest it, but an email reminder once in a while,
and that's
probably.
my point.
But we all have full-time something else.
We didn't solicit that input. And I think we need to do that before the next meeting.
Well, if you want to withdraw the motion, fine. If you want to keep it, then we vote on it. But if it's there, we have to act on it.
Well, my only point is that we did get it Monday, but it is a one-page document. It's only relative to the qualifications. It's not a heavy lift. We're not limiting it to the people, as Barry correctly comments. There's lots of other people we could consider. It's a small thing that we can check off tonight at 20 of 6, and we don't have to do next time. I understand the comment that Ann makes that we don't want to be too limiting, but. It's not that complicated a document, and I've had a chance to read it. I'm just thinking, we had a chance to all have input. Some of us did, some of us didn't.
I think it's pretty simple. Are you leaving the motion or not?
I'll leave the motion.
All right, are you still seconding it?
Sure.
All right, we have a motion, we have a second.
I would move to amend it then. That if it's really what you're really saying, Mike, is we can always expand it, then I would move to amend it. The QA and AC could include, but should not be limited to, but might not be limited to. I mean, really.
Second.
All right. Is there anyone in favor of that amendment? I think we have to vote on the original motion first, right?
You vote on the amendment first.
Amendment first.
All right. Is there anyone in favor? We have an amendment. It's seconded. Is there anyone in favor of the amendment?
Just say the amendment again?
Someone's asking that you repeat the amendment.
QAAC will be comprised of, but not limited to. It's just adding that not limited to.
Yeah.
No, not, all right. The amendment is could be comprised of?
Yes.
But not
But
limited
not
to.
limited to.
How many people are in favor of that? We've got 1, 2, 3, 4, 5. How many people opposed? All right, so that goes down. So now we have the original motion.
I'm opposed to all this. I just want the record to reflect I warned you guys.
How many people in favor of the original motion that Kathy made?
Another amendment. Instead, you don't like could.
Is this a filibuster?
No, but not limited to. It's your suggestion, Mike. You were saying, well, we can always come back again and expand it. So why don't you put it in there? Why don't we just say, but not limited to?
It seems meaningless to me, but, all right, you've made another amendment. Does anyone second Barry's amendment?
I think it's unwise and meaningless to continue voting on this. I don't see what the purpose is unless it's an attempt to lock something in that we haven't really had an opportunity to debate or consider. I don't really see the burning necessity of doing that.
If you asking for more time for discussion, go ahead.
Well, yeah, it's pretty clear to me. I don't see the necessity of doing it. But my clear amendment is, why don't you just say, if you can't go with could, the QA-AC will be comprised but is not limited to. Subject to, do that.
Isn't that what we just voted on?
No, it said
No,
could.
I put in the word could.
So now you've taken could out?
Yes.
Will be comprised of, but not limited to.
Does anyone second that amendment?
Second.
All in favor of that amendment? All right, we have 1, 2, 3, 4, 5. All opposed? All right, that amendment goes down. Now we're back to the original motion. We have a motion, we have a second. Anyone in favor of that motion? 1, 2, 3, 4.
Fitz abstain?
Yeah, I'm abstaining. I don't say. Shouldn't vote on this shit.
That doesn't pass.
And all opposed? All right, so that doesn't pass either. So it looks like we don't have enough votes to do anything at this point. So if there's no objection, I would ask for a motion to adjourn the meeting and table all of the items that we didn't reach until our next meeting, which is on June 26th. Do we have a motion? Do we have a second?
I second.
All in favor?
There's supposed to be a time.
We have 15 minutes, but I just got to count.